Okay, so we have your W-2 and mortgage deduction, your receipts, charitable deductions, mileage claims. Let's see, are we missing anything else? Oh, do you owe any use tax?
What's use tax?
It's usually owed when you buy something from an out-of-state company or website that didn't charge you California sales tax. So do you think you may owe use tax?
Gosh. You know, I did a lot of online shopping this year. I think I have some receipts from a few things I bought.
Oh, that's easy to add in on your return. Let's see what you have.
The revenue collected from use tax helps pay for important California services like public safety, healthcare, and schools. Remember, when you file, pay your use tax. To learn more, visit boe.ca.gov. Paying your use tax. Good for you, good for California.
The Taxpayers' Rights Advocate of the State Board of Equalization wants you to know you have rights. As a California taxpayer, your rights are protected during the assessment and collection of taxes, including the right to courteous and prompt service and the right to be treated fairly during all dealings with Board of Equalization employees and officers of the Board. Publication 70, Understanding Your Rights as a California Taxpayer, and Publication 145, California Taxpayer Advocates, can be useful in learning about your rights. If you feel the BOE has not resolved your concerns adequately, please contact the Taxpayers' Rights Advocates Office at 1-888-324-2798 or email us. The Taxpayers' Rights Advocate of the State Board of Equalization. We're here for you.
It's easy to buy things online these days, but did you know you may need to pay tax on those items?
Really?
It's called use tax. And just like sales tax, the use tax you pay to California will help fund important services like public safety, healthcare, and schools. But how do you know if you owe use tax? When you buy things online, look to see if you were charged tax when you checked out. If you weren't, you may owe use tax. It's easy to figure out how little you may owe. For most purchases, you don't even have to save your receipts. Just use this convenient use tax table, available in your income tax instructions. Find your adjusted gross income to see how much you may owe, and enter that amount when preparing your state income taxes. It's that simple. No looking through files and no hassles. You've paid your use tax for the whole year.
That was easy.
Paying your use tax. Good for you. Good for California.
We're committed to supporting our communities, teaming up with businesses large and small, improving our roads and schools, investing in law enforcement and our environment. Together, we're funding a better quality of life. We're the California State Board of Equalization. The BOE was created in 1879 to equalize property tax assessment practices throughout California. Our responsibility has grown quite a bit since then. Today, the BOE administers more than 30 taxes and fees that provide 1/3 of all the revenue generated in our great state. And we're efficient. More than 99% of the money you contribute supports services and programs that benefit all of us in California. When you drive down our many highways, see a police officer helping someone in need, or enjoy a walk along a pristine beach, think about what makes it possible. Whether you're a business owner, making a purchase, or just filling up your gas tank, your contributions are important to our state's economic health. And the greatest part, we're doing it together. We're ready to work with you. Take advantage of our free seminars, helpful classes, instructional videos, and mobile applications. Also, use our online services. It's easy to do business with us from anywhere, at any time. Our partnership equals success. Learn more at boe.ca.gov. Together, we're supporting our communities and funding a better quality of life.
Okay, so we have your W-2 and mortgage deduction, your receipts, charitable deductions, mileage claims. Let's see, are we missing anything else? Oh, do you owe any use tax?
What's use tax?
It's usually owed when you buy something from an out-of-state company or website that didn't charge you California sales tax. So do you think you may owe use tax?
Gosh. You know, I did a lot of online shopping this year. I think I have some receipts from a few things I bought.
Oh, that's easy to add in on your return. Let's see what you have.
The revenue collected from use tax helps pay for important California services like public safety, healthcare, and schools. Remember, when you file, pay your use tax. To learn more, visit boe.ca.gov. Paying your use tax. Good for you, good for California.
The Taxpayers' Rights Advocate of the State Board of Equalization wants you to know you have rights. As a California taxpayer, your rights are protected during the assessment and collection of taxes, including the right to courteous and prompt service and the right to be treated fairly during all dealings with Board of Equalization employees and officers of the Board. Publication 70, Understanding Your Rights as a California Taxpayer, and Publication 145, California Taxpayer Advocates, can be useful in learning about your rights. If you feel the BOE has not resolved your concerns adequately, please contact the Taxpayers' Rights Advocates Office at 1-888-324-2798 or email us. The Taxpayers' Rights Advocate of the State Board of Equalization. We're here for you.
It's easy to buy things online these days, but did you know you may need to pay tax on those items?
Really?
It's called use tax. And just like sales tax, the use tax you pay to California will help fund important services like public safety, healthcare, and schools. But how do you know if you owe use tax? When you buy things online, look to see if you were charged tax when you checked out. If you weren't, you may owe use tax. It's easy to figure out how little you may owe. For most purchases, you don't even have to save your receipts. Just use this convenient use tax table, available in your income tax instructions. Find your adjusted gross income to see how much you may owe, and enter that amount when preparing your state income taxes. It's that simple. No looking through files and no hassles. You've paid your use tax for the whole year.
That was easy.
Paying your use tax. Good for you. Good for California.
Good morning, everyone. Welcome to the second day of the State Board of Equalization. Ms. Richmond, will you please call the roll?
Chairwoman Ma,
Here.
Ms. Harkey,
Here.
Mr. Horton,
Here.
Mr. Runner,
Here.
Ms. Stowers.
Here. Okay, there is a quorum this morning, so we will convene the Board of Equalization. Ms. Richmond, please introduce our first item.
Good morning, Chairwoman Ma and board members. Our first item on today's agenda is item C, Sales and Use Tax Appeals Hearings. Item C5, Bodywise International LLC. Please come forward. Board Proceedings has received contribution disclosure forms for today's hearings from the parties, participants, and agents. All forms were properly completed and signed, and there were no disqualifying contributions disclosed. All parties, participants, and agents are on the alpha listings provided to your office. Each person sitting at the table will be asked to introduce themselves and, if necessary, their affiliation with the taxpayer for the record. 10 minutes is allocated for the taxpayer's opening presentation, followed by 10 minutes for the department's presentation, and 5 minutes is allocated to the taxpayer for rebuttal. Ms. Ma?
Okay, thank you. To appeals, Mr. Njija, please introduce the issues in this case.
Good morning, Madam Chair and members. I am Jeff Njija on behalf of the Appeals Division. The appeal before you presents one unresolved issue, which is whether tax reimbursement that petitioner collected on its interstate commerce sales must be paid to the board.
Okay, thank you. So to the petitioners, welcome. You'll have 10 minutes for your presentation, initial presentation. Then the state will have 10 minutes and then 5 minutes on rebuttal, and then the board will open for questions. So thank you. Please introduce yourself for the record and begin.
Thank you, Madam Chairwoman and members of the board. My name is Jesse McClellan on behalf of petitioner, Bodywise International, Inc., and I also have Lucian Khan, who is also on behalf of the petitioner. The issue that we would ask the board to address today is whether or not sales taxes of other states are due to California. And as some background to the case, the petitioner operates a multi-level marketing business selling nutritional products. During the audit period, which covers approximately 2005 through 2009, they were registered and sold into approximately 35 states, including or in addition to Canada. The software system that they used to apply the tax to their transactions and for reporting purposes was incorrectly set up to apply tax to some states in which they were not registered. Upon audit, the Sales and Use Tax Department looked at the sales tax accrual account, compared the total amount that was in it to what was reported to California, and because of the Canadian and the other states' sales, there were significant differences. The vast majority of those differences were ultimately resolved because it was recognized that the sales were reported to other jurisdictions. It took a long time, but eventually what they realized was that there was an error in the way that the system was set up, and that there was tax applied by the system to invoices that would be issued to other states. I've provided today an exhibit, and there's 2 pages. Page 2 of that exhibit is an example of an invoice that would be issued. And you'll see that this shipped to and the sold to is a particular individual. And a little ways down before the line item, you'll also see the identification of the distributor. So as a multi-level marketing business, the sale typically would go to a distributor who has a relationship with the petitioner, who would buy these products, and then they would sell them, resell them at a markup to their customer. And in any event, the issue, again, simply stated, is whether or not those taxes that were collected from another state are due California. And the code section that's on point, which is also on page 1 of the exhibit that I provided to you, and the relevant language we've highlighted, states that when an amount represented by a person to a customer is constituting reimbursement for taxes due under this part. So, in other words, where a sale is made and the seller represents to the purchaser that is charging California tax, then this code section applies. The code section is implemented under Regulation 1700. And the rules go on to state that to the extent California tax is applied to a transaction and it's not actually due California, then there's two options. It goes back to the customer, and if not, it goes to the state of California. Notably, there's no third option. There's no third option to pay it to another state. So if it's truly due California, you can't satisfy the obligation by paying it to another state, which is a question that we've asked of the department to explain, but it hasn't been, because the department has, during this process, said, well, if you pay it to another state, it's no longer due California. Well, if it's actually due California, you can't satisfy an obligation by paying it to another state. So we haven't come to understand how that question is being answered. And in any event, the department and appeals positions to this point have been that 6901.5, while it says that it applies to sales taxes or taxes that are represented as California tax, that the regulation doesn't. And because the regulation doesn't contain that limiting language, that it's permitted to essentially expand to any taxes. And really that can't be an accurate assessment, because the regulation springs from the statute. A regulation, of course, explains what the statute says. And the board is granted authority to adopt regulations under Code Section 6051. And that authority, of course, is limited to explaining what the code section says. And with the exhibit provided to you, we quoted Government Code Section 1134.2.2, in a relevant part that says that no regulation adopted is valid or effective unless consistent and not in conflict with the statute and reasonably necessary to effectuate the purpose of the statute. We also provided a quote from the Nortel Networks case, which cited Woods v. Superior Court, a 1981 case that was issued by the California Supreme Court. And it says an administrative agency may not promulgate a regulation that is inconsistent with the governing statute or that alters, amends, enlarges, or impairs the scope of the statute. So the statute says that it applies to scenarios where it's represented as taxes due under this part, so represented as California tax. The regulation cannot, and it does not say, it doesn't say that you can't do it, which goes to another case, but it certainly doesn't say that it applies to all taxes in the United States. And it couldn't under those provisions. And another case that we looked at that we felt was on point to this is the Diageo-Guinness case. In that case, it involved a situation where the Board of Equalization sought to redefine what constituted a malt liquor and redefine it in such a way that it was considered a distilled spirit as opposed to beer or wine, and thereby subjecting it to a much higher excise tax rate. And ultimately, that was challenged, and the taxpayer essentially asserted that the ABC had the authority to define what a distilled spirit means. The board, in response, argued that there was nothing that said that they couldn't pass the regulation. The court explained that the board, like most agencies, is a limited power agency, and they're permitted to do that which they have authority to do, not to do everything but that which they're prevented from doing, and ruled in favor of the taxpayer and found the regulation to be invalid. The other factor that I think helps to make it clear that we're not really even in the confines of what the regulation says is the fact that the department has said that even though they're asserting that this amount is due California, that the amount can be satisfied by paying it to another state. So if there's a liability that's asserted that's truly due California, There's no circumstance under which you can pay it to another state to satisfy it. And if the board were to rule that way, then arguably it would create a situation where taxpayers could take tax that it applies to California transactions, let's say an out-of-state retailer that ships products to California, charges a California tax rate, which therefore is represented as a California rate under the facts of those circumstances. And its home state essentially says, we'll pay it to us, or if they pay it to the home state in error, under the framework under which we've been dealing with this case, arguably that would satisfy the obligation that's truly due California. The other issue is that appeals has said at page 10, lines 5 through 9 in the decision or recommendation that there's a recognition that the taxes were due to the destination jurisdiction, but that when it wasn't paid to the destination jurisdiction, it became California tax. Again, we don't see how that occurs under the law. At the time of the transaction, the nature of the tax is established. So we would ask the department, if they could, to explain two things. Number one, how do you satisfy an obligation truly due California by paying it to another state? And number two, how does a tax which is identified as a tax due another jurisdiction become California tax if it's not remitted to that jurisdiction? Because certainly that jurisdiction would disagree with that point. And with that, we'll turn it over to the department. Thank you.
Okay, thank you very much. The department, you have 10 minutes. Please introduce yourself for the record, and then you may begin.
Good morning. Good morning, Chairwoman Ma, members of the board. I'm Scott Claremont with the legal department. With me are Lawrence Mendel and Kevin Hanks, also representing staff. We concur with the recommendation of the appeals division, and no further adjustment is warranted to the audited measure of excess tax reimbursement collected by petitioner. Petitioner sells weight loss and nutrition products. Its orders were shipped from a California warehouse via common carrier, and the sample invoices provided by petitioner show that an amount simply described as tax was added to the price of the property sold. Audit staff determined that during the period at issue, which was April 1st, 2005 through 2009, petitioner collected approximately $104,000 in excess tax reimbursement in excess of the tax it paid to California and other jurisdictions. At issue is the approximately $62,000 in tax reimbursement plus interest in excess of the tax reimbursement collected on sales in interstate and foreign commerce. Under the Revenue and Taxation Code, sales tax applies to all sales that take place in California that's not subject to a statutory exemption or exclusion. Section 6396 provides an exemption for sales in interstate commerce, meaning, as relevant here, sales that are completed in California and otherwise taxable, but where the retailer ships the property to a point outside the state by a common carrier. Section 6901.5 requires that when a retailer collects excess tax reimbursement, it either return the amount to the customer from which it was collected or remit it to the board. It defines excess tax reimbursement as an amount represented to a customer as constituting reimbursement for taxes due under that part, sales and use tax law, upon an amount that is not taxable or is in excess of the taxable amount. Regulation 1700, which clarifies and interprets Section 6901.5, defines excess tax reimbursement as an amount represented to a customer as constituting reimbursement for sales tax upon an amount that is not taxable or in excess of the taxable amount. Here, petitioner holds a California seller's permit and added amounts represented simply as tax to sales that were completed in California that would have been otherwise taxable if not for the statutory exception. Therefore, these amounts meet the definition of excess tax reimbursement under Section 6901.5 and Regulation 1700. Since petitioner has not returned them to the customers, it is required to remit them to the state. As pointed out in the hearing materials, the board has a duty to protect the integrity of the sales and use tax law, and the excess tax reimbursement statute was specifically intended to prevent unjust enrichment by retailers. Yet petitioner is asserting a very narrow construction that's not in the plain language of the statute, by which an amount simply labeled as tax by a California retailer on sales completed in California somehow is not represented as sales tax reimbursement simply because it a rate could be backed out of it, and that rate could be determined to not be the same as the applicable California rate. And that's pretty much the only factual distinction between this situation and any other situation where excess tax reimbursement is charged on an interstate commerce. Such a narrow construction is not contemplated by the language of the statute, nor is it consistent with the board's interest in preventing unjust enrichment. As to that, I note that petitioner continued to collect excess tax reimbursement for several years after this period, and we are now 12 years from the start of this audit period, and petitioner is still retaining these amounts. So unjust enrichment would certainly occur if the petitioner were allowed to keep this. For all these reasons, the petition for redetermination should be denied. Thank you.
Okay. Mr. McClellan, 5 minutes on rebuttal.
If I may, the rebuttal.
Okay.
I just want to recap the relevant facts, the law, and the analysis in this case, because I think that the answer will be obvious what the board should do in this case. First of all, we have software that's designed to, I'm sorry, Mike. Can you turn that up? Yeah. You have software that's designed to calculate the correct amount of tax. That's what the software did. It calculated the tax for the state of destination. And that's really undisputed. If you look at section 6901.5, which is at issue here, and you look at the language, it says, when an amount represented by a person to a customer as constituting reimbursement for taxes due under this part, well, it has to mean what it says. If you're talking about taxes due under this part, they're talking about taxes due the state of California. So the only real logical interpretation of this statute is a retailer has to represent to a customer that I'm collecting California tax, that this is tax due the state of California, and that I will be giving the tax to the state of California. Therefore, to have a violation of Section 69, if you don't have a violation under Section 6901.5, Regulation 1700 just simply does not apply. In other words, the rules, give it to the state, give it back to the customer, it doesn't apply. And the reason why there's not a third option to give it to another state, because it was never contemplated that 6901.5 would ever apply to a situation where a retailer is collecting another state's tax. The Department and appeals have both accepted that the tax collected was not California tax. And I'll read you exactly what it says in the DNR. On page 10 of the DNR, lines 5 through 9, appeal says, we conclude that petitioner and its customers in the other states and Canada agreed that the indicated tax was sales tax that would be remitted to the appropriate jurisdictions. So what are they saying? They're saying, yes, we agree that this is not California tax, but that it would be remitted to the appropriate jurisdiction. In other words, the other states. Then it goes on to say, when petitioner failed to remit the entire amount to the appropriate jurisdiction, the unremitted tax became excess tax reimbursement payable to the board if not refunded to the customers. Well, this begs the question, how can you say the tax was other states' tax? Now that it's not remitted to those states, it's all of a sudden California tax. It is not California tax. Oh, yes, it is, because you didn't pay it to the other states. Well, how do you do that? The law doesn't provide for anything like that. It doesn't change its character just simply because of some action or inaction on the part of the taxpayer. Then in the SDNR, this is on page 4, lines 3 through 15, appeals basically says, in the DNR, we found that excess sales tax reimbursement was collected. And it says that they relied on, in part, on annotation 460.0242. There's very little similarity on the background facts on which the annotation is based. In that case, the only similarity was there were exempt sales in interstate commerce. In other words, the other taxpayer made sales and shipped the goods to customers in other states. For some reason, that taxpayer collected an extra amount that was deemed to be tax, and the taxpayer paid that tax to the board. So the two big differences between the facts on the annotation in the current case is, number one, in the annotation, there was no mention that another state's tax was being collected. And number two, by the other taxpayer paying the tax to the board and filing a claim for refund, the other taxpayer was treating it as California tax. So you have facts which would lead a reasonable mind to conclude that in the background facts in that annotation, it was understood to be California tax, not another state's tax. So we're saying that the annotation just simply does not apply. The relevant facts are different, and appeals relied on it, and it should not have relied on it. Since everyone agrees that the tax was not represented or collected as California tax to be paid to the state, it cannot be excess tax reimbursement by definition, nor do the rules under Regulation 1700 apply. They just simply do not apply. And the department, even in its presentation today, and in the DNR and the SDNR, the Department and Appeals has not explained how tax, which everyone agrees was not California tax, becomes California excess tax reimbursement simply because it was not paid to the other states. Okay, the simple answer to this question is they can't come up with an answer because there is no legal authority. Section 6901.5 does not support the department's or the appeals position. There's no legal authority that supports this position or any reasoning which the department or appeals has taken in this case. The bottom line is that the appeals conclusion is it's not based on the facts, it's not based on the law, and we are simply asking the board to grant this petition because 6901.5 and Regulation 1700 and the rules in Regulation 1700 simply do not apply to this type of situation. It's not California tax. The board just simply does not have jurisdiction over the matter. It's a matter between the taxpayer, its customers, and the other states. Thank you.
Okay, thank you. Mr. Renner.
Yeah, let me go through a couple of things here. In the illustration that you, or in the invoice that you gave us as a copy, which is a South Carolina, yes, South Carolina invoice.
Yes, sir.
So the tax was collected by the retailer.
By petitioner, yes.
By the petitioner, yeah. Were they registered in South Carolina?
That particular invoice is meant to serve as an example. I don't know the answer to that question.
You know, that's not relevant, you don't think?
No. Really what we're looking and what we're asking the board to do here is to
let me broaden the question.
Okay.
Were there states where they collected this tax and they were not registered?
Yes.
Okay. What was the intent then?
Well, really the intent, you would have to go back to the person that set up the software system. The person that set up the software system, as we at least speculate, occurred, clicked a button that, as an example, clicked South Carolina. When in fact, the taxpayer wasn't registered in South Carolina, so it wasn't preparing returns.
So it was an error.
It was an error with the programming of the software system.
So it was an error.
Yes.
And this particular error took place in 2006 that you gave us this for.
That's an example. I don't know that is, I don't know if they're registered or were registered in South Carolina.
Okay, I'm not talking about the registration, but this particular error, in terms of the collection of the tax without remitting to that state, was in 2006 was an error.
That's correct.
Okay. When was the error discovered?
During the audit.
Which
well,
was,
frankly,
give me a date.
It was really, we weren't involved with the process. From looking at the record, the best we can tell is that it was discovered sometime after the audit process was complete, and potentially during the appeals process.
So give me a date.
I don't actually have a date.
Give me a year.
I don't have a year, I'm sorry.
Okay, let me go back to, when would that have been if it was after the audit?
The original audit report was September 2010.
Okay, so let's say it's 2010.
I don't think it would have been, because based on a reading of, the initial audit assessed $2 million. So the audit report that was initially issued made an assessment for all of the tax that they had collected. So it was really through a lot of work and effort by both sides, both the department and the taxpayer, of going through this And there's still amounts, for example, that.
Okay, hold on, just a minute.
Okay.
I'm trying to get to a date to when the item was, when the error was discovered.
Okay.
Okay. You had told me that was, at least you had just reported that it was at the end of the audit. They just gave me the date of the end of the audit. Now you're disagreeing with that.
Yes, well.
Okay, so give me the date when you think that, when it was discovered.
To clarify, it would have occurred sometime during the appeals process. Because the audit was issued, there was a very large liability which represented the tax.
Was it 3 years ago, 2 years ago, 5 years ago?
Yes.
It would have been, yes.
Okay, so the error was discovered, let's just pick a number, 4 years ago. Okay, let's pick a number. The error was discovered 4 years ago. What has Body-Wise done to return the money that was collected in error?
Well, for part of it, because this error wasn't recognized for a long period of time, some of it's been paid to the state of California, and a claim for refund has been filed for that. So they've paid $124,000 to the state of California. And otherwise, what they've been doing is arguing.
Has it all been paid to the state of California?
Not all of it.
Okay, so the part that wasn't paid to the state of California, what have they done over the last 3 or 4 years back to the consumers? Or to a state, which I guess is one alternative.
They've sought to resolve the issue with California is what they've done. That's been the focus.
So there's no intent then to return the money to the consumer?
That's not what I said.
Why wasn't there an effort made to do that?
There has been significant efforts made, including us sitting here today, to resolve this so they can address this with their customers.
Well, you don't need to come here to return the money to the consumer.
Well, actually, we do.
Why?
Because California has made an assessment.
Well, let me ask you this. Let me go back to appeals. If indeed the money that was collected in the excess reimbursement that was collected was returned to the consumer,
We wouldn't be sitting here.
we wouldn't be sitting here, correct?
The regulations compels that they pay it to the customer or to the state.
Okay.
They paid it to the
So
customer.
again, let me ask you, why did Body-Wise choose not to resolve this issue as simply as returning the excess collection back to the consumer?
Well, the way that my client understood it, and the way that I've looked at this case and understood it, is that to the extent it's been paid to another state, then there's been a credit provided, or to the extent that it's paid to Canada, there's been an offset in the audit. The audit started at $2 million. They eventually got to the point where they realized what occurred. It was a long process through both sides working through it. As we sit here today, there has been notifications to these distributors, for example, and to the area managers that this is an issue that they're addressing, and once it's resolved, the idea is to provide a credit to their customers. But
why? Okay, knowing all that, why wouldn't you bring that plan to the board now so we could see that? So then, see, here's the challenge that I have. Honestly, I feel like there's an enriched retailer out there, and I'm feeling like there was ways for them to resolve this issue before it even came to us. That was just returning the excess collection back to the consumer. So it seems to me it could have been done earlier, and we wouldn't even be here, or it could be done now with a plan coming forth, so that we don't have to make a decision whether or not the state of California should get that money or whether the consumers get that money. I think the consumer should get that money. But right now, I have no reason to believe that the retailer would do that, because there's been years of collection that they've been sitting on that they chose not to do that.
And I totally respect the concern. And it's a concern that we addressed with our client at the forefront of this. They understand that they can't simply retain this. I don't view it as a California issue. I have more concern with the states that the destination is made. Really what we're here today to do is to ask the board to address the legal issue. I completely understand.
If we address the legal issue and find in what it is that you are asking for us to do, we have no indication other than what you're telling us, that the intent of Bodywise is to return the money to the consumer?
Well, I would.
Or keep the money?
I would suggest that there would still be a statute of limitations there. There's also money that they've paid to
the statute of limitations?
Well, the department could always go back to the taxpayer and see what was done. And if, frankly, they didn't do what they said they were going to do, then that could be something that would be addressed. But as it pertains to unjust enrichment and the examples in the law that we see, those are scenarios that pertain to tax that is collected from California. And in this case, we're essentially, well, we, as the state of California, or the board, if you will, is seeking to administer taxes of other states.
Why would you even want to bother bringing this to us when it could be resolved by simply returning the money and not having to address that question?
That's a good question, but I think that the question we're asking to have answered is whether or not 6901.5 applies at all, and if it doesn't, then it's a matter.
If the retailer would have done the right thing, we would not even be here to answer that question. That question wouldn't even be on the table.
I respect that you see that perhaps they didn't do the right thing.
You think they did the right thing?
Well, I think that what they're doing is within the law and that they intend to give it back to their customers. So I think.
And the indication we have for them and their intention to do that is what?
Well, they're trying to get out of the issue that the department has created. They've paid a large percentage of this to the Board of Equalization. And we're here today to try to resolve this issue so they can address it with their customers, which they see it as being an issue between them and their customers. So what we're asked to do is to when I was talking with my client, their question to me, for example, is, well, why does California have a claim to these amounts? Well, I don't have an answer for that. And ultimately, why are they, why would we have to act under the guise of the Board of Equalization for an issue with a client or for a customer in another state? Again, I don't have an answer for that. That's one of the reasons why in our presentation, we're posing these questions so we can have answers to those. I think they're reasonable. I think it's reasonable for a person in a business to the extent they have the right to address an issue directly with their customer, that they be able to exercise that right. If the amounts are truly due California, we don't have a dispute. And as the department pointed out, there appears to be some reconciliation differences with respect to California. Those are not an issue. We're not saying, look, leave the taxpayer alone, let them do what they want with respect to those amounts. But as it pertains to other states, we believe that the law doesn't apply.
Okay, thank you.
Thank you.
May I just add something? It's just conversations that.
Very quickly.
Yes, I will. In the conversations with the taxpayer, basically their question was, well, if this is not California tax, then why is the board trying to tell me what I have to do with the money? And our answer was, well, that's a good question. And the taxpayer said, and the reason why we're here at the board hearing today is because the taxpayer wanted to get the petition granted on the basis that it's recognized that this is not California tax. So it's basically the taxpayer just wants to be able to make the final decision without the board.
And that issue is so
forcing it.
important to the taxpayer that he's willing to keep other people's money.
Well, I can't say the motivation of the taxpayer, but the question just simply became,
Okay,
if
thank
this
you.
isn't. Thank you.
Okay, Ms. Harkey.
Okay. I think that Mr. Runner kind of went through all of the points that we're all questioning here, and I think this is a very difficult case for you to be pursuing. So I think that's why Member Runner was trying to get to the bottom line as to what happened with the money. Was perhaps, I mean, if Bodywise International is truly retaining the excess tax amounts, that would mean to me that's part of the sales price. Did they report that as part of their income? I mean, did they make an income adjustment for income tax purposes? Because you're kind of going around and around here, and I don't understand. You got the money. What'd you do with it?
Well, so in total, I believe there's, let's just call it $220,000 total at issue between the two periods.
Now I think it's down to 61 or 67. Yeah,
As
almost
the department pointed out, this issue wasn't fixed, if you will, for a period of time. So there's another audit period. Now, $124,000 of it sits in the Board of Equalization accounts. So the other amount, obviously, is still with the taxpayer. As it pertains to their income tax reporting practices, I can't speak to that. But we completely respect the board's concern here. What we're asking the board to do, and obviously the decision is up to all of you to make the decision, is to look at the law. And there's cases oftentimes where the result sort of pains you because the right decision under the law is such that you're telling perhaps a mom and pop grocery store that they have to pay a large liability. And it may not sit right, but ultimately that's what the law dictates. That really is our focus here. I've been given unequivocal assurances by my client that they intend to address this with their customers and to give a refund via credit to their customers, to their distributors primarily, that essentially work for them. These products are resold, generally speaking, to the end customer. And that's really what we're here to do, is to ask whether or not under 6901.5, where there's a recognition that it's not California tax, if it's an assessment that can be made and due to California. Because if these aren't paid...
Mr. McClellan, I'm
Yes.
sorry.
Okay.
I've heard you.
Okay.
I heard all of this.
Right.
With all due respect,
Mhm.
I want to allow you your time.
Okay.
But I'm not completely convinced that the board has this broader authority, but what I am also not convinced of is that there's any intent to just retain the money or not to report it as income. I don't know what, and I think I have to go back to what Senator Runner said, that
Mhm.
it's just really, it's tough to determine what it is this is. If it's not taxes due to California, then it's got to be part of the sales price. And if it's part of the sales price, then minus all the expenses, it's all got to break down and go into net income somehow. And if it didn't go into net income, and you're not reporting it as a part of your sales price, and you're reporting it as tax, and you're not remitting it, and you knew you had a glitch, I just, as much as we can correct,
And they didn't know of the glitch.
Excuse me,
Sorry.
I'm just really, if the taxpayer's intent is to keep the amounts represented as tax, and we have no other way of finding out what it is we're really going to do with this, I have to kind of rule on the side of the department, because what they've got is pretty clear. And I'd like to help you, but I'm just not sure I can get there on this. Thank you.
I respect your concerns, and ultimately, the only thing that I can say is what I've been told by my client.
Right.
Which is that they fully intend to, and it makes perfect sense to me that they would frankly have to. Given the circumstances that we're in a public hearing now, it's well understood what took place, that they have to address this with their customers.
I think you're in a tough position coming into this so late. Oh, I appreciate.
Yes.
I appreciate. Thank you.
Any other questions? No? Okay. Mr. Brenner?
Here's the dilemma I'm in, and that is I'm hesitant to fine for the department because I really don't want California to be enriched in this process either. I want the consumer to get their money back. So let me just ask appeals a couple of paths here that we might try. If we were to go with a 30-30-30, continue the hearing, and then during that time, the taxpayer could demonstrate then their plan and assure us that money was being refunded, the excess collection was being refunded. Could that happen during that 30 period of time?
It might take longer than the 30,
Okay,
30,
right.
30, but it could be arranged, yes.
And ultimately, then, if we continue the hearing, if things didn't then work out, they'd be back in front of us to deal with it.
Yes.
Okay, then I'll make a motion for a 30, 30, 30. With that as the intentions, I think as I just shared, that they would indeed come up with a plan that would indicate, work that out with the department, and indeed if the department was satisfied with that, then it can be settled. If it can't be satisfied, then we'd be back here to talk about it some more.
I would second that.
Madam Chair, just a question of the
Mr. Horton.
department and possibly appeals. The plan itself, is that sufficient, or does the law require that the refund take place?
Mr. Horton, typically in these situations, we would look to see that the refund has taken place or a credit's been offered to those customers. And if notification is made to those customers that there's going to be a credit, assuming those customers have an accounts receivable, then that's sufficient for us.
Yeah, I'd agree with the concern that Member Horton has, is I think this means more than just, hey, here's a written plan. We need to have the assurances that the department is satisfied that the law is met.
Right.
Yeah, under that, I would be supportive as well.
If we had some flexibility with the 30, 30, 30, might
Yes,
take
you
more
have
time.
flexibility with 30, 30, 30.
Okay, so there's a motion by Mr. Runner, seconded by Ms. Harkey for 30-30 with some flexibility. And if it doesn't satisfy the department, then we will be back on the credits or refunds. Okay. Thank you.
Thank you, members.
Without opposition, such will be the order. Next item, Mr. Chair. Thank you.
Good idea. Good idea.
Our next item, C7A and C7B, they are running late.
They have train issues.
So would the board like to take up the legislative committee? I'm not sure if staff are here. And I don't think staff are here for the property tax committee.
Property tax committee's here. Yes? Let's do the property tax committee first then. Okay,
so-
Mr. Horton?
So our next item is the property tax committee. Mr. Horton is the chair of that committee, Mr. Horton, and we do have several speakers.
Thank you, members. Noting the quorum, the Property Tax Committee is hereby called to order. We would ask that any speakers on this item come forth in order to expedite the process and just have a seat. We will have you subsequently introduce yourself. You've not filled out the appearance sheet. Members, I would ask that we hear from the department first to go on record, and then proceed to the witnesses that are coming forth, and back to the department to allow them an opportunity to respond. With that, we would ask staff to introduce themselves for the record and commence with their report.
Hello, Property Tax Committee Chairman Horton and committee members of the board. My name is David Young, Chief of the County Assessed Properties Division in the Property Taxes Department. With me is Mr. John Loudon, Senior Auditor Appraiser, also of the Property Tax Department. Thank you. I bring before you today the issue of what representative period should the board adopt for the year 2017 tax year for the assessment of aircraft operated by certificated air carriers. Revenue and Taxation Code, Section 1152, requires the board to designate a representative period. This representative period is used to measure an aircraft's physical presence in California and to allocate that presence amongst the counties within California. Issue paper 16-12 was developed and circulated to provide background information on this issue and to provide 3 alternative courses of action. Alternative 1 has 2 parts. Adopt the week of July 10th, 2016 through July 16th, 2016, and the week of January 8th through January 14th, 2017 as the representative period. The second part is to also recommend board staff and county assessors to evaluate in 2017 the potential of using the 12 months prior to the lien date as the representative period for the future. Alternative 2, the board would adopt the 12-month prior to this lien date as the representative period. And alternative 3, the board could adopt the week of January 8th through January 14th, 2017 as the representative period. Staff recommends that the board adopt alternative 1. I am available if you have any questions.
Thank you very much. To the witness today, we would ask that you introduce yourself and then proceed with your testimony in the order that you're currently seated. Please.
Good morning. Thank you, Mr. Chair Horton, Chair Ma, and members of the board. My name is Rich Benson. I'm currently the president of the California Assessors Association and the Marin County Assessor Recorder County Clerk. With me here today, and I'll let them each introduce themselves, Ron Thompson, Assessor for Alameda County. From Los Angeles County Assessor's Office, Brian Donnelly and Neil Najjar.
Please commence, starting with you, Mr. Benson.
Thank you. As the board members know, and they've had their opportunity to look both at the issue paper and probably have been familiarized with the ongoing process of determining the representative period for a number of years, that this has been a discussion item amongst assessors, board staff, and the legislature and industry and interested parties. It's been a long, ongoing process. The hope here today and the position of the California Assessors Association is to recommend supporting staff recommendation number 1 to select a two separate week representative period, one in January, one in July, as suggested in the issue paper. Assessors believe that this provides an opportunity to really capture the average representative period over the course of the year rather than just looking at a finite point in time, be that as it may. A single week in the year is not necessarily reflective of an average over the course of the entire year. In additional to that, the assessors also support the position that we look during the course of 17 at the opportunity to explore and determine whether a 365-day representative period is even better than looking at that 2-week period, and that gives us the time in 17 to evaluate that with staff. Assessors are committed to ensuring that we have consistent and contiguous assessments of airlines over the course of the year for 17, and are working diligently amongst all assessors to ensure uniformity for the assessment of aircraft and ensure that there's collaboration and cooperation amongst assessors. With that, I would point to Mr. Thompson if he has any additional comments, and if there's any specific questions from the board, certainly our experts from Los Angeles County are happy to help with that.
Assessor Thompson.
Yes, good morning, Chairman Horton, Chairwoman Ma, and members of the board. I'm testifying as the Alameda County Assessor and as Chairman of the CAA, California Assessors Association Airline Assessment Committee. I also would like to express my support of staff recommendation number 1, to use 1 week in January and 1 week in July as the representative period to use for the assessment of certificated aircraft in 2017. I recognize, although it's not ideal, just using 2 weeks, the recommendation gets us much closer to appropriately assessing certificated aircraft in the state of California using actual 365-day representative period for 2018 and beyond. Thank you.
Thank you. Does that conclude the testimony? The other individuals are here for expert response.
Anything to add?
No, I believe you've covered it. So.
Are there any other witnesses on this issue? Please come forward. We would ask that the experts provide us them an opportunity to speak. We will call you.
Welcome to the Board of Equalization. Please introduce yourself for the record.
Good morning, Mr. Chairman. My name is Eric Metke. I'm with Nielsen, Merxmer, Parinello, Gross, and Leone. And I'm appearing today on behalf of Airlines for America, the industry group that represents the vast majority of the commercial aircraft owners that would be affected by the board's action today. A4A supports alternative 3. We do not support the staff recommendation, and nor do we support alternative 2. And let me just give a little reason why. Let's start with a little background. The representative period has been the same week in January since about 1997, and it was moved to that period when the lien date was moved from March 1st to January 1st in 1996. It was prior to 1997, and at least as far back as 1980, which is where we stopped looking. The representative period was immediately proximate to the lien date. A few days before, a few days after, but right around the lien date. That's been very significant, and as the chairman and members know, the lien date is the significant date on which we take the snapshot of the value of property in California. So that's the significance of having the week in January. It wasn't something that was just cooked up. It was put there because it's always been proximate to whatever the date of the lien date was. There was, when it was moved from March, a week in March to a week in January, there was no great disturbance in the force or in the universe. Nobody said, all of a sudden it became non-representative because we moved the month. So I just want to give you a little bit of historical background on that. The staff report mentions also that in 2013, input was sought on this issue from the assessors. The report, though, of staff in connection with this issue didn't really quote what was said when that project was ended, was terminated. It said, after reviewing the comments submitted by interested parties, staff has determined that there is, quote, no compelling reason to change the representative period from longstanding week in January each year. Therefore, the interested parties process for this review has been concluded. So we haven't seen any data. No one has provided us any concrete information that suggests that there's something wrong with the January date. There's nothing there. And there's nothing in the staff report. The most we've been able to get out of staff about why a second week should be added is that it was in AB 2622, that particular week in July. Well, what we pointed to that, of course, is that that bill was not adopted, and it's a little ironic in the staff report on the our proposed property tax rule 475 that was withdrawn, the fact that the legislature didn't adopt a bill extending the valuation methodology was cited by staff as a reason that we shouldn't go ahead with that valuation methodology as a rule. So here, it appears to be the exact opposite position, that despite the fact that the legislature didn't adopt 2622, now that becomes the recommendation for the second week. It's a little ironic. In the absence of some compelling evidence up front to change from the 1 week, we think it ought to remain the 1 week, and we would ask the board to do that. And with that, I just want to stress one thing, is there's also, I think, a belief that somehow there's some magic computer button that the airlines push to get this information generated. It's just not true. At least the airlines that I've spoken to, at least one of them, this is a manual process. There is no magic data bank that they are able to generate this report from, that then turns into the property tax return. This one airline had 700,000 flights in and out of California in a calendar year. If you do the math on that, that's about 200 flights a day, I believe, or 2,000 flights a day. And then each one of those flights, to do this calculation, is at least 3 or 4 separate calculations. So even adding an additional week adds a huge compliance burden. And when we don't really know whether we're going to get a better answer or not, then it seems like a large compliance burden in exchange for maybe worse information. If that second representative week is less representative than the first, then you're getting a worse result. So for those reasons, we would ask the board to stick with the current representative week and not adopt the other two alternatives. I'm here to answer any questions of the board, and thank you.
Thank you. The board would ask the next witness to introduce herself for the record and then commence with her presentation. Ms. Reese?
We'll let Mr. Lang go next, if you don't mind.
Mr. Wish?
I've been often confused.
Please introduce yourself for the record, sir.
So Joe Lang, representing A4A, Airlines for America. Madam Chair, board members, we're here just to provide brief comment. I'd like to follow up just a couple quick things that Mr. Methke said. Right now, we would support continuing the existing one representative week period, understanding that potentially adding a second week without having all the appropriate data could either overweight or underweight the representative period. The whole idea behind a representative week is to find that happy medium that actually reflects the amount of time that an aircraft is in California for taxation purposes. Not that easy to do. We understand that. We've been in very significant discussions with assessors for quite some time now, trying to find that right way to allocate the amount of time that an aircraft is in the state of California, both in the air and on the ground. We haven't found that exact way to do it yet. There's a variety of factors that are involved. There has been a proposal to see if in fact there is a way to develop data that would provide a 365-day-a-year, very specific data approach to determining exactly how often and when an aircraft is in California. That requires that data, if in fact ultimately becomes available, requires essentially the merging of at least 3 databases, which are completely separate, not all controlled by the FAA, for example. There's the air traffic control data system, there's the geopositional satellite system, what's called the ACARS system, which also feeds through traffic control but gives geopositioning specific data. And then there's the data that the airlines have relative to where their aircraft is at any one particular time. And without getting too technical, the difficulty about doing those measurements is those are all measured by waypoints that are used where the airplane actually, the computer systems communicate through the waypoint to traffic control. There may be, and I wouldn't be surprised if sometime in the future there is technology that in fact would allow for that pinpointing of time to occur. But right now, unfortunately, there are not all along the border of California waypoints that measure exactly at the border. And developing that data right now may very well result in a 2 or 3 minute error for a flight, depending on whether it's diverted for weather, traffic, or whatever. It's a lot of technology that needs to catch up. Ultimately, that would provide the most accurate data because it would give you all and the assessors in the state the picture of exactly how long an aircraft is in California. We don't have it now. What we have is a system that's been relied on for many years to pick that representative week and then have the airline provide that specific data using rules that you all have developed relative to timing of flights. We do think there is a way to arrive at a consensus on how to do this approach, and we look forward, even though we did not succeed in coming to a consensus with the assessors last year in the legislative process. I don't think it means it couldn't happen, and in fact, I think right now the differences we have may be small enough that would allow us to come to a consensus, at least how to work forward until the ultimate data on a 365 basis is available. If and when that data becomes available, I think we all look at it to determine its accuracy, see if it's appropriate, and if so, that's what gets used. But until that time, we have to have a system. We think the current one representative week is as close as you can get to determining that without overweighting or underweighting, and we'd appreciate the time to continue to work with the assessors to ultimately come up with what will be the most accurate system.
Thank you.
Catherine Reese, representing Southwest Airlines. I don't have a lot to add to what has been already said. A couple of points I would make is to really emphasize what Mr. Lang has said. The labor intensity and the convolutedness, both in terms of manpower and technology, is rather overwhelming for an airline of Southwest size to go to the 365 proposal. The assessors have been discussing this for 2 years. They attempted it legislatively. They attempted the July week legislatively. That did not come to fruition for a lot of the reasons that have just been discussed here. In addition, there have been attempts with this board to move the representative week to Christmas week, and that did not prevail here. Next, it was Easter or spring break week, and now it's a second week in July, which is one of the 6 busiest weeks in the airline business. So there's clearly a trend as to where they are moving, which for us means and translates to a categorical deliberate tax increase. And we don't have the information that we think would justify that. As Mr. Metke pointed out, the point in time that's been selected in the representative week has been around for a very long time and has been satisfactory to all until most recent years. So we would encourage you, in the spirit that Mr. Lang has outlined, to adopt the current representative week at this point. Thank you.
Please introduce yourself for the record.
John O'Malley with California Advocates on behalf of Delta Airlines. Delta is not a member of A4A, and I felt it incumbent on myself to at least say that we agree with our colleagues in the rest of the industry. The current system was developed by Mr. Horton when he was a member of the Assembly and perpetuated by Ms. Ma with her legislation that removed the sunset and extended the sunset. And we agree with the comments made by Mr. Metke, Mr. Lang, and Ms. Reese. Thank you.
Thank you very much. Members, I'm going to ask Mr. Benson, Assessor Benson, to come forward and provide any additional historical perspective he might want to provide. Then we'll go to the department, see if there's any additional input there in order to assure that the members have all the information that they need in order to deliberate on this matter.
Thank you, Member Horton. I am going to ask Neil Najjar to speak to some of the specifics on the details regarding the rep periods, although I will like to comment just briefly on my understanding and what I've heard in the commentary, although the facts I think will be provided in some measure by Mr. Najjar, that the January week is one of the slowest weeks of the year. So trying to find some other week to try to create an average or something that's representative for the entire year. Clearly, if the data was available and the parties could agree that having the data for the whole year would allow you to statistically find an average may be the best thing. But certainly looking at a single week in the year that may be one of the lowest or slowest weeks of the year statistically is equally as difficult or impossible to prove that it's representative of the year unless you have the year's data. So an equally valid argument may be, well, let's enlarge the sample size to at least cover 2 years, which statistically provides a better sample than if you're just looking at one. It enlarges the sample size. If you can get the entire sample size and take the average, that is really the ideal. If in fact what we're looking for is a representative period of the year, and even if you were looking at a lower week and a higher week, taking the average may in fact represent something that's more reflective of the average for the entire year. Mr. Najjar can elaborate on that and maybe provide a little further background.
Good morning, Chairman Ma and members of the board.
Mr. Najjar, would you please introduce yourself for the record?
Yes, Neil Najjar. I'm a supervising appraiser for the Los Angeles County Assessor's Office. Back in 2013, we gave an extensive analysis to the BOE staff that attend our California Advisory Subcommittee meeting, which is a subcommittee of the California Assessors Association. And we extrapolated data going back to 2007 regarding how the flight activity is mapped throughout a calendar year. And that was really the source of this. And in that research, we found January to be really one of the lowest months of the year to gauge flight activity into the state of California. And you know, we sampled 7 of the largest airports in our state, including Los Angeles County. And the thought was, you know, absent of the 365, which is what we strive for, which is the actual data, you know, to obtain an average for a calendar year, we want to look at the lowest point of the year and the highest point of the year and come up with an accurate average. And that was the proposal at the legislature last year, with going with a January week and a July week, which is the board's proposal, and we agree with.
Thank you very much. Members of the department, any additional comments?
No, I think Mr. Najjar summed it up very well. We did have a look at that 2013 analysis that he provided, and it did array the activities through the year, and they represented, it looked like it picked the high and the low point.
Members, just as a quick overview, not really getting into the specific, I'll kind of wait until the debate on that. The inherent, first let me thank both the assessors and the industry for indulging the committee with another 30 days to see if it was possible to come up with sufficient evidence to support one way or the other. The inherent challenge that we sort of face in selecting the lowest and the highest is statistically that does not provide you the medium. It creates an imbalance, if you will. And so the objective is to try to find a period that is representative of the entire year. And that theoretically, the objective statistically is to take a look at the medium and then look at the deviation that occurs from one month to another in order to establish what the average was. And it's that kind of data that I believe is necessary in order for a change to occur. The other inherent challenge that we have, if we don't get it right, or don't at least statistically try to take a look at it, is the mere simple sample size alone statistically does not determine in and of itself that you have now equity in your calculation. Give you an example. If you were to test 1,000 Democrats, you would get a different answer than if you were to do a similar sample of 1,000 Republicans. But if you were to test 500 of each, you might get somewhere in the middle at the end of your results, or at least be able to support that they totally disagree. The other challenge is that so it brings us down to an arbitrary selection of a period in time that in and of itself, there are so many other variables that can contribute to whether or not those periods are representative. For example, the airline could very well, as they seem to have done, is market extensive marketing causes the period of January to all of a sudden appear to be a nice period. And the same influence could be yielded in the period of July. and particularly given that both periods seems to have these holidays of December and November in and around those periods of time. So all of this says to me is that there needs to be some effort in order to assure that there is a compelling statistical, numerical, quantitative, and empirical data to support that we are at the means, the average. And with that said, it presents, in my opinion, it presents the board with the challenge of saying, well, without any evidence, without that data, it's difficult to recommend that we need to begin to modify things. But it is very easy to recommend that it is in the best interest of the state of California that we come up with the methodology to compute this on a 365-day basis. It is hard for me to not believe that in this environment of technology that we can't get there. And maybe the incentive have not been provided, and maybe there needs to be legislative incentive in order to encourage that to happen, or possible funding, possible tests, or a study bill that sets aside another separate entity that will study this and come up with the methodology that is agreeable to all of the parties. And so personally, let me just say publicly, I'm very supportive of the 365-day calculation, because I think it gets us there. I think it meets the objective of both parties, is to report the most accurate amount, and we should do what we need to do in order to get there. But at this point, it becomes all these different challenges. I was hopeful that we would come up with something other than an arbitrary number that was presented to the legislature and probably rejected by the legislature for the same reason that I'm proposing today. Anyway, that's just an overview of members of what we've gone through in the last month. I believe going forward we can get there on the 365. I believe we can get to some resolution between the industry and the department, the industry's desire for a legal judicial review just doesn't seem to be practical. Let me just put that out there as well as a means of trying to pull us together. With that, thank you very much for your indulgence, members. Mr. Runner.
Yeah, just a couple of questions. Let me just, I'm trying to interpret a little bit of what you were going through there. I believe if what I heard correctly was alternative 3, however, with the addition of the second point of alternative of the staff recommendation. Did I kind of get that correct?
Yes, Mr. Runner.
Okay.
I mean, to the extent the board can actually sponsor something that motivates this to happen or creates an environment financially where this can happen, we should probably take that responsibility.
Well, I guess part of our responsibility certainly could be trying to keep the parties talking.
Yeah.
And I kind of find myself a bit in the same spot. I'm hesitant to add an additional representative week that, again, I have no information about whether it's representative or not, and I think Member Horton points out, I'm not sure having 2 of them and averaging them ends up with a calculation that is, in the end, the right calculation. So I would have difficulty just arbitrarily right now for us to go to the first part of the board recommendation, staff recommendation, with adding the second week. I certainly am open to the idea of asking the parties to have a collaborative process. The thing that I see lacking in the second point of the staff recommendation is I see the board staff and the assessors evaluating, but I don't see the airlines in that calculation. That's in that recommendation. So I don't know if that was intentional or if that just was.
It was not intentional, sir.
Okay, so indeed, it would be the intent to also then include in that discussion
interested parties.
Interested parties. Okay. So again, I'm open to that. I don't know the challenges of the 365 and whether or not that is indeed an available alternative. I think that's what that discussion would be all about. It seems to me it does change the calculation a bit in that right now we have it based upon a lien date for the particular year. If you do 365, you must have to then go a year in review or something, correct? I mean, just either part, go ahead.
You are correct. It would have to be the previous year, and one of the issues to be discussed, of course, is when you're assessing tax on the lien date for the following year.
Right.
So how representative is that, even though you have an entire years of data, because in the ensuing year, you
So
may
my
be
only point, I
adding
guess,
it
my only
back
point
in
is
place,
that
right.
it actually not only changes the calculation, but it also changes whether or not you're looking forward or backwards too, which again, doesn't necessarily mean that's good or bad, it just is a part of that discussion.
Mr. Runner, if I may, that's another challenge that we sort of face. Changing the methodology at this point affects 6 months previous, which activity and where.
I mean, adding the second date.
Yeah, where the industry has made all kinds of decisions based on a law or this particular rule that existed, which is inherently always challenging to make a rule that affects someone retroactively, you know.
Mr. Chair, may I address that?
Here, I got running the floor here right now, so I'll go ahead real quick.
I think that's always a challenge in appraisal and assessment and requires some measure of judgment in looking to see what's happening in trends and patterns, whether it's the industry or the housing market or some other type of thing that we assess in trying to get some idea. Clearly, if you're looking at a period of time where you can maybe forecast what's happening, that gives you some perspective. The other option is you put your head in the sand and you pretend that something that may not be true is reflective of what actually is true. What we haven't done, and with all due respect to all parties, is look at the actual data and say, do we have enough information to make a valid judgment? I still believe that looking at more than 1 week, it adds something to that equation. Whether or not it represents the exact mean or median of a year, we'll have to see. On the other hand, if the process is so difficult in getting the parties to agree or getting 365 representative period data because the data itself is so difficult to gather, then you're back to saying, okay, do we just look at 1 week, which may not be representative of the whole? So I think there's some element of judgment that enters into the equation to think, how do we get a reasonable representation of the period for the entire year?
Okay. I think I'm finding myself, I think, pretty much in the same spot as Member Horton. I'm prepared to make a motion, but I think we need to hear from the other members first.
Chairwoman Ma.
So I was also the sponsor after Mr. Horton in this whole airline issue, and it was one of the most controversial bills that I carried because of the nature of it, and we see that continues since the legislature could not pass either a sunset or come up with a new agreement over the last 2 years. I'm also uncomfortable, being here at this body, making those decisions. I think it's really the legislature's job to, decide what it is that is, best for the state. We are more of an administrative body, and we are, supposed to do what the legislature intends us to do. And I understand that the legislature has not acted, and so we are here today, and it makes me very uncomfortable that we are going to determine policy or be the de facto legislature for this issue that the legislature cannot agree on, right? I think I have said in the past that, moving forward with the status quo is what I'm most comfortable with, given that the legislature has not decided what they would like to do moving forward. But I also would like to see real data. I think that is the best way that we should be evaluating these types of situations based on real data. I haven't gotten an answer, a straight answer, whether the real data is available. It's easy to calculate. I have been asking that question, and I'm not sure that anybody in this room really knows how accessible and how easy the information is to get. But in this era of technology, I would assume someone has it or someone can get it, because people are doing business and flying around the state, and everybody knows where everyone's going. Otherwise, there'd be a lot of accidents, right? So somewhere it's out there, right? And I just don't know, I can't get my hands on how accurate this data is, right? So I don't know, where my colleagues are. I'm willing to, if we have to make a policy decision, I'm willing to say we're going to keep the 1 week representative week for this year. If the legislature cannot come up with it, then, maybe we need to make a decision here to, like my colleague said, force everyone to go back to the legislature and figure this out. That if they can't do it, then we are going to make that decision. And I think the legislature may, jump on it because they don't want us to make those decisions. Once it sets a precedent that we are going to make those decisions, then it kind of takes it out of their realm. So I don't know what the carrot and the stick is for this process to get everybody back to the table and, negotiating over there. But that's kind of where I am at this moment.
Member Stowell.
Thank you. Just kind of clarification to industry. I believe you said that if the second week was added, it would be a compliance burden. Could you clarify exactly what you would have to do? What are you doing for the first week, and what's the manpower and so forth to pick up a second week?
Essentially, the data we have to provide ourselves. We have to make the calculation as best we can, how long an aircraft is in California, both in the air and on the ground at the airports. Doing that for 1 week, several thousand flights, several thousand calculations, which we have to basically use the hardest data we have. The bottom line is nobody knows exactly when that aircraft passed the border of California. You can get as good as you can get. You might get within 2 or 3 minutes of that, but we don't know for sure. But we collect that data and we submit it. Adding a second week essentially doubles that administrative burden without providing an increase in accuracy or an assurance that at the end of the day we haven't overweighted or underweighted depending on the week that's chosen. At the end of the day, the answer is to get the hard data. It does require the merging of 3 independent software systems. We, last year in our discussions and significant efforts to reach agreement in the legislature, the first part of our negotiating sessions were made under the assumption that, in fact, the FAA would be providing that data. What happened, unfortunately, is that in the middle of the summer last year, the FAA then unfortunately said, no, they will not be able to provide the data. So we were basically stuck without that accurate data. And so what it would do is require those calculations to be done for a second week. And it's thousands of calculations.
Thank you.
If I can just comment on that.
Sure.
With, the current statute, and I want to make 2 points, mandates that after consulting with the assessors in the counties where aircraft are situated, that a representative week will be assigned. The only thing we're trying to do is to come up with a reflection of what occurred in the prior calendar year. In regards to the FAA data that was just mentioned, we have been working closely with that agency, and I know some of the board members have had staff working on with the FAA directly, and we do have, or will be getting data, and have been getting data since October of 2016 directly from the FAA, and will continue to do so going forward. Okay. Just to make that point.
Okay, I just kind of, my point here is that I am concerned that a second week would be an added compliance burden, but it does seem a little odd that we're only looking at the lowest travel week in January.
Yes. To
get to the representative period. I also believe that having an analysis of over 365 days is best, but obviously we're not there yet, and that's the second part of alternative one, is to look at how that data can be obtained and evaluated.
And the data that we provided the board in 2013, all airport agencies in California have stats that they publish to the public. And in there, they show volume of flight activity in and out of an airport. And what we did is we compiled data from 7 different airports for all takeoffs and landings, and they report it by month. That data is available, Chairman Ma. And we actually derived flight activity for every month of the year, going back to 2007. And we looked at the trend, and that's why it sort of migrated towards a January, July timeframe. And going back to Board Member Runner, the question about was the industry consulted, the statute doesn't dictate that. It says after consulting with the assessor, the board will place a representative week to be used by county assessors statewide. Thank you.
Member Harkey.
Okay, I just have a few things to add. I want to remain with alternative 3 for all of the reasons that were mentioned here. And while I'd like to explore if the data is available to ascertain a 365, I'm not so sure that even gets us where we want to go. Because if you're doing 365, you're doing retroactive. And I know I fly Southwest every week, back and forth. The flights change. They're all over the place, depending on the need for the plane. And so how does, if let's say, Southwest brings in an extra flight during this time and then takes it out for the next year, or adds extra, or other carriers add extra places, or add extra planes, extra inventory, how does that get me close to that lien date that I'm trying to get to? I think it's a retroactive, and unless we're going to go back and readjust for previous years, I think we'll have a problem with the 365 look back. As for representing or doing anything like the housing market, you don't add inventory to it. If you do, it's through a permit and you assess it at a new value. This is a totally different, so I can't see that correlation with the housing market or any other thing that is assessed, quite honestly. And I just, I'm having a real problem until we can get data, accurate data. I really don't want to place more burdens on everybody to keep rehashing this out. I'd like to see the board, or I'd like to see the legislature be the place where it gets hashed out. And for the board to go back in and keep holding interested parties and all this on this, I think gets us away from where it should be, is the legislature. The legislature needs to take an action to determine. The legislature determined January 1st is a lien date, I'm assuming. And so then the representative month was close to the lien date. If they want to change the lien date and use another representative month, I guess maybe that applies if you're doing 1 week. But I can't get there as to why this is necessary now. So I appreciate everybody continuing to work together. We will see our assessors tomorrow, and I know we're always working together. But this is one area where we've kind of gone around and around on. I was in the legislature for 6 years, and so, there doesn't seem to be a clear path. So I would, until we can get real accurate data and know what it takes to get accurate data, I just want to recommend alternative 3. And maybe the staff to come back to us and let us know if there's any way of concocting accurate data for a look back, since that's the way this board seems to want to look at it. But other than that, I really don't want to do the interested parties and all that kind of stuff. I think we have what we need until the legislature acts.
Thank you, Member Harkey. Members, I want to share just with the industry, Chairwoman Ma spoke about the hammer, which I think is brilliant in the legislative process. And quite frankly, I think the Board of Equalization is that hammer, in that we do have the authority to make this determination, and I believe we have the authority to go even further. And let me say to the industry that I believe the board will go further if this isn't resolved. The January period, over a period of time, as I reviewed the data, over a period of time has become among the lowest. You could get even lower if you looked into February if you wanted to. And the other period is among the highest. And so the objective has to be is just to get it statistically right. Not who's high, who's low, who pays more taxes, who pays less taxes. Let's just get it statistically right. And there is sufficient data out there, which was really surprising to me that we weren't able to kind of accumulate that data and figure out what a reasonable medium was, or means was, in that 1 month period. But now we're faced with this deadline, so we can't continue to work on this. We have to make this decision today. And in the absence of, the data, the calculation almost, the data's there. I believe the data's there. I think we may not be able to get 365 days, but we can come up with a statistical formula that kind of gets us where we need to be as far as trying to determine what the means and the medium is. And I think that's where we need to go, members, is staff needs to continue to work on this. Take a look at the 2013 data. Take a look back at the data previously prepared, which is available, and let's develop something other than an arbitrary selection of just 2 periods in time, and maybe a more extensive period than just a week. And at the same time, I'd encourage both parties, or probably the industry, to proceed with a legislative fix as well, and we'll do the same on our end as far as the Property Tax Committee is concerned. With that, members, I'd entertain a motion.
Adopt alternative 3.
Member Harkey moves to adopt alternative 3, second by Member Runner.
Objection.
Objection noted. Madam Clerk, please call the roll.
Mr. Horton?
Aye.
Ms. Ma?
No.
Ms. Harkey?
Aye.
Mr. Runner?
Aye.
Ms. Towers?
No.
Motion carries.
Thank you very much. We look forward to continuing to work with the members on this, but thank you for your time.
Thank you, members of the board.
Thank you.
The Controller Yee is here for the item that we will call out of order.
Yes.
Yes. Okay, Ms. Richmond, please announce the next item.
Our next item on the agenda is Customer Service and Administrative Efficiency Committee. Mr. Runner is the chair of that committee. Mr. Runner?
Thank you. And we will call to order the Customer Service and Administrative Efficiency Committee. This is a discussion in regards to the outreach plan. And I think we have some staff that are prepared to go ahead and start with the presentation.
Yeah, thank you, Chairman Runner and board members. Good morning. My name is Mark DeCio, and I'm the Deputy Director of External Affairs. For your consideration and approval today is the Board of Equalization's statewide education and outreach plan. The Board of Equalization is committed to helping all Californians understand and comply with the state's tax laws. The Harris-Katz California Taxpayers Bill of Rights mandates that the BOE develop and implement a taxpayer education and information program, which must, among other things, reach out to newly registered taxpayers, including mailings, written communication, small business seminars, taxpayer educational materials, and continuing education programs targeting common areas of noncompliance and explaining tax compliance in simplified terms. One of our strategic management plan goals is to maximize voluntary compliance with the objective to enhance our understanding of taxpayer needs and expectations and continually improve our education and outreach efforts to help taxpayers comply. In previous years, the education and outreach plan was presented on a calendar year. This year and going forward, staff recommends shifting to a fiscal year. The plan before you today is intended to support agency-wide outreach activities for the remainder of this fiscal year. We intend to present the fiscal year 2017-18 plan to the board in May. As the board directed at its December meeting, this plan includes an allocation of funds for regional outreach activities. Staff recommends an allocation not to exceed $800,000 for the remainder of this fiscal year. This allocation is based on historical trends and is intended to support outreach activities such as printing, postage, and venue costs. The allocation would be managed by the External Affairs Department. Additionally, this plan includes information on innovative new solutions that focus on serving the maximum number of people in the most efficient manner, and also documents the recent board-adopted policy on VITA outreach. We plan to continue to look for additional efficiencies and innovative new education and outreach solutions. With your approval, we will proceed with the education and outreach efforts planned for the remainder of the fiscal year and bring the fiscal year 2017-18 plan to the board in May. That concludes my presentation, and I'm happy to answer any questions that you may have.
Okay. Questions that we may have?
Comment.
Controller Yee.
Thank you, Mr. Chairman. I have a couple of comments. One, I first want to just say that I support this construct of having an allocation that would be then divided among the board members for priorities in their districts for education and outreach. I just wanted to speak a little bit about the amount because so over the course of the entire fiscal year, we're talking about $1.6 million?
Correct.
Okay. That's a lot of outreach money.
It's comparable with the past years.
And what you included in this was print, postage, travel, venue costs, other related costs. I mean, I think part of the problem is that we haven't had the best tracking of these costs, but given that you incorporated all of those based on kind of past year, did that include all of the VITA-related events as well?
Yes, it did.
And why aren't we backing those out pursuant to the discussion we had at the last meeting?
Come again, please.
So I guess we weren't going to like have each member can prioritize whether VITA is something they want to allocate a portion of their amount to, right?
Correct.
So, but as an agency, when we're developing the overall budget for the members, why are we including the VITA in the overall cost?
Well, the VITA, I see your point. The VITA in the past was included in our historical data. Going forward, my understanding is that we could also subsidize VITA if it's part of, say, a business seminar, a business tax seminar, or a business resource seminar, or an event that we're already putting on. We could do posters around that. We could do some advertising around that, is my understanding. So you're right. The historical trend is going to be higher than going forward with VITA costs.
So I guess, Mr. Chairman, I would like to see if we can bring this amount down. I mean, this is member prioritized outreach with this allocation
right.
on top of what the agency outreach would be.
Well, it's
No.
yes. It's.
I have to.
Yes, ma'am.
No, go ahead. Go ahead.
Yeah.
Go ahead and answer the question.
Well, it'll be allocated to the External Affairs Department, and it's kind of like what we do now in terms of we let the members know what they're spending in terms of postage, mailing for their events that they have. We would like to track this allocation the same way, except monthly. Let board members know, you've spent X amount this month.
Maybe just to clarify real quick, and I don't know, maybe this is where the question was, but this would include then the business, small business seminars.
Yes.
This would include the nonprofit seminars, which again, I'm not sure if Controller Yee sees those as member specifically driven or agency driven.
I guess that's my question, is this the full complement of all outreach for the agency?
It is the full complement.
Okay. So there's no additional kind of outreach division costs. So this would be the entire budget for outreach for the division. Okay.
Yes. For the External Affairs Division, yes.
Right. Okay. All right. So this budget then, the entire budget would then be allocated to members?
To External Affairs.
To External Affairs for working with members?
Correct.
Okay, so let's say if it is $800,000 for this half year,
Yes.
Is it contemplated that that allocation would be then for all outreach for that 6-month period that would then be driven by members' priorities?
Well, yes, but I would like to say that working with me, I have outreach managers in each division, and they're called the outreach leads. And so, for example, in Mr. Runner's district, we have James Barrett. And I can list all of the different people. And I sit down with them biweekly. And we develop at the beginning of the calendar years, the way it has been, a schedule of events that we're going to do. And so we prioritize the things that the members want to do, the things that work well with external affairs. So that's how we set our priorities, and that's how things are budgeted in tandem with the member offices.
Okay, that makes sense.
Yeah.
So 2 things I want to be sure of with this. So one, I appreciate and want to give members flexibility in terms of prioritizing outreach needs in their district. That makes sense to me. What I don't want to discourage or kind of get the agency down the path of is lacking consistency in terms of how we do outreach.
Right.
From an agency-wide perspective. And I also don't want to discourage the development of more web-based and other flexible tools for outreach.
Yes.
And so I would hope that over the course of the years to come, this number goes down in terms of actual event-related, hard mail-related type of outreach. And so I'd like to see some kind of strategic, direction about where this is going, and that we're not going to be approving a $1.6 million allocation every year for the same.
Yes, ma'am.
Okay. So that's
Okay.
a concern. And then I would like to kind of entertain potentially taking that $800,000 down, because if VITA was included in the overall mix of this, and we're going to treat VITA a little bit differently in terms of having members fold that into anything else they're doing, I think it may warrant taking this down by $200,000.
Okay, let me real quick, let me just make some overall comments in regards to the report and the committee in regards to that. I think it's very important for us as a board to move forward with some parameters. I think we are under some appropriate scrutiny in regards. It's then I think important for us to respond, and so I think it is vital for us to have this discussion, give some kind of parameters, and that we all then feel like we can accomplish in that process. I'm a little concerned about taking down the number arbitrarily, because, again, I don't know what percentage of those dollars were used for VITA. So I think what we do have before us is the opportunity, and that is, since this is a 6-month opportunity, I think what we have is the ability for us to go forward with this kind of issue and then come back then in, I think, May. Is that what I understand?
Yes, sir.
Come back in May then with a more definitive report as far as how these dollars were spent, and then can make a better decision in regards to dollars going forward. So I think we can accomplish that in that regard. And indeed, if indeed then, as we know, the VITA dollars are not going to be then used as a part of these discussions, then in theory, those dollars, the $800,000 will be used less, and therefore we'll have a more exact number going future into the next year. So I think that accomplishes that. I'm just concerned about being arbitrary in regards to the amount.
Yeah. Mr. Chairman, if I may.
Yeah.
No, I'm open to that. I guess what I would then ask for is some way of, maybe too soon to get this, but certainly how the dollars were used, but it would be great to put some sort of evaluation mechanism in place.
I think the May report should include as up-to-date use of this current period as we could factually put together. And I think it would be easy, because at that point we may come to May, but we also though know what the expenses are going to be for the rest of the year, through June, because these are all budgeted items that are planned. So even though things may not have taken place in the month of June, we will know what the costs are going to be throughout the whole 6-month period. Correct?
Correct.
Okay. So I think that the report coming back in May needs to be inclusive of that.
Yes.
Okay.
Okay. Member Harkey.
I'm just a little bit puzzled, because I have never directed outreach. We have, it doesn't come from the member office.
Right.
We may make suggestions as to where we think we need to do some outreach, but that's all done through the department. We do not have a member budget. I don't budget these things. We do, for the board-wide, we have a budget for outreach, and that's a board budget. So I think the events for every member are already planned through the year, which is why I would be kind of opposed, VITA or no VITA, to cutting it now, because I think the IO staff and the outreach people have already got their programs in place, and we can see them on the website.
Correct.
What we're having, when we're having it, and where we're having it. That being said, if, this last 2 years, we went into areas where the board had never been, into underserved areas. We were heavy in Chula Vista, which the board had really never had outreach programs in. For some reason, and we went into El Centro. We went out to Riverside quite a bit. We're trying to hit the areas where we have a lot of small businesses, and because my district had not really, I think Orange County had a lot of events, but it was the district, the allocation of the district dollars right now or the outreach dollars for the district have been throughout all 4 of the counties on a regular basis. So we kind of had a lot of catch-up to do. And in those outreach programs, like I said, in Chula Vista, in Poway, in those areas, we've had 300 people show up. They really want the information. So I think we're doing a good service. And but I did not direct that. We said, have we been to these areas? And the outreach staff, who reports through Mr. Dicio, said, no, we can do that. And so that's how we organized it. And I did not personally show up at all of those events. I picked a few here and there when I was in town, but I did not show up. So I don't consider this a board member budget. I'm not sure how we're going to allocate that, because I don't direct the IO staff. I don't direct the outreach staff. That's not what I do. They report through the board. They are board staff. Not my staff. And so, and as for the VITA, I think when we did VITA in our district, what I saw about the VITA outreach was predominantly done with the use tax or put in with other programs. Now, I know there's been some question as to whether the staff is used or not. We thought that staff was not used, was not taking their personal time to do tax returns and whatnot, or taking their BOE time to do tax returns. I'm not sure how all that's worked out, but I think we've got that pretty well squared away at the last meeting. So I understand everybody's concerns here, but what I think I need to stress, and I want to stress particularly for the press that's going to come out on this, that we do not do outreach. And I don't think there's any board member up here that does their own outreach. I consider my own outreach to be my campaign mail, but I don't consider it to be when we have a small business seminar. So, that's board business, that's educational. When we have a nonprofit seminar, that's board business. And so, other than my name being up there as being a board member, it's not, So that's just the points I want to make. I just want to be sure that there's a clear understanding as to who handles the events, who gets these events approved, who goes through legal. I don't do that. I don't do any of that. I don't approve the posters. I don't approve any of that stuff. So I just want everybody to know that's the fact. It really is handled through the board, through Mr. Dicio. Mark.
Yeah, Mark's good.
Mark's good. Through Mark and his people in each of the districts, who then have their people out in the district. That's how we handle it. So.
And if I could just respond, Ms. Harkey, just to be candid, I'm used to working with budgets, and when I arrived, there was no budget for external affairs, so I'm trying to put that in place.
Okay, good.
Yeah.
That's a goodie, and that's good what's come out of this.
Yeah.
Member Horton.
Thank you, Chairman Runner. Members, what might be helpful here is if the agency was to provide more of a historical perspective on outreach. I believe if they were to do that, they would find that prior to the district liaison and the expansion of the outreach unit, that the districts spent somewhere around, in 2009 and 2008, $41 million in staff time in order to do the basic sales and use tax classes, the electronic filing classes. There are probably somewhere around 4 different sets of classes. We spearheaded the sales and use tax class in district, I don't know what the district number at the time, but it was under the leadership of Matt Fong, and it was continued through the rest of the members. And so what the districts would do is they would conduct on a monthly basis sales and use tax workshops for new permittees. Those workshops would include an entire marketing program. They would include staff dedicated to developing developing, planning, and presenting the marketing program, and they would do it on a monthly basis. So if you were to take a district similar to District 3, what you would find would be is that the districts are conducting, let's say on average, 3 classes a month. That's 36 classes per district a month, including advertising, outreach, and so forth. This is just your basic sales and use tax class, your new permittee class, and electronic filing, and so forth. And if you had 5 districts, that would be somewhere around 180 classes in the district. And the cost was quite high back in those period of times when that was occurring. The board historically, and the other historical data that I think might be important for the agency to verify and to report out is the budget associated with marketing and outreach and education prior to electronic filing. Prior to electronic filing, we would send out permits, returns to every taxpayer. 1.3 million on the average would receive a document. They would also receive notice of changes in the law. They would receive notice of changes in policy and so forth. And that information was expensive and was reinforced by classes that would take place that I mentioned before, which in 2008 was somewhere around $41 million, as opposed to what we're looking at here. And the marketing and outreach was almost 300 times more than what's currently occurring. With the implement of the district liaison program and the awareness that electronic filing took place, the board had to make a decision: how do we continue to educate our constituencies about the 32 different tax and fee programs that we administer, and the various different requirements that the legislature had placed on the board pursuant to the BCPs, which is another area I would encourage the department to take a look at, is to reconcile the outreach to the budget change proposals that we put forth to the legislature. Most recently, the legislature has allocated $5.3 million for outreach in the medical marijuana and marijuana field, $5.3 million. And this budget doesn't necessarily reflect those efforts. And so there are some 7 or 8 BCPs where we've told the legislature that we're using these positions and we're using these funds to do education and outreach. And so whatever we put forth as a budget, I think there's a level of wisdom being consistent, that should be consistent with what we've told the legislature in that regard. The new marketing strategy, if you will, accomplished a couple things. One, instead of doing 180 to 260 different workshops, the districts now do 16. Instead of having on an annual basis where you would have somewhere around 4,600 people attend these workshops, you could now have up to 3,500 people actually register for one workshop, because the Board of Equalization adopted what I thought was a wise strategy, was to enhance the product to such a way that the consumers would be more interested in participating, but providing them information not only on the Board of Equalization, but the Franchise Tax Board, Employment Development Department, Insurance Department, and so forth, is what these seminars currently do. And so using the economy of scale, we were able to actually reduce the costs. The other historical data that we might want to present to the board and accumulate is the cost of facilities. During that time, prior to my arrival and soon after, but it stopped, the agency would actually use hotels in order to conduct some of the conferences conducted at the Long Beach Sports Arena and so forth, which was relatively expensive. The agency entered into an agreement with the legislature and the state and others to use state facilities, which significantly reduced the cost of presenting education and outreach. And the other thing that I think the agency did that was a lot of wisdom in it was in their marketing, they also included an educational component. So the individual that received the information would be educated about much more than just coming to the event. I.e., the VITA initiative educates the taxpayer about use tax, which is due, educates the taxpayers about the sales and property tax exemption, which, based on historical data, presuming 100% compliance, the VITA program currently prepares tax returns in the state of California for somewhere around 280,000+ individuals, of which previously they were not necessarily reporting their use tax. But if they were to be educated about use tax, or presuming 100% compliance, you're talking about generating a $3 million additional revenue for the state of California just on use tax alone. And the cost associated with that, and particularly in District 3, as far as the mailing is concerned, I can't recall, but I think it was like 30,000 or 40,000. I don't know what the number is. But the benefit from it is huge. And I think the inherent challenge as far as the public's concerned is that we're not giving the public all of the information, making it as transparent as possible. With all of this in mind, I really don't believe any funds should be allocated to the members. I don't think the members ought to have any control over these budgets whatsoever, none. I think that we should establish a process when I believe the process is in place, but obviously there are some that don't, but a process that says, let's determine if this meets whatever you're doing, if it meets the requirements, the legal requirements in order to do it. Is there a governmental purpose? Is it consistent with our mission? Is there a return on the investment? If we do that, are people attending, which is an indication of the desire and the need? And what you will find is the new way the board has been doing over the last 3 years, as far as marketing, the attendance has increased almost 300%, as opposed to the business and use tax classes where you would have 15 to maybe 50 people attend. Now the sales and use tax classes, you got anywhere from 100 to 300 to 400 people attending. So it's actually more efficient and effective, and that the agency should be making this decision, you know, through the office, the outreach element, reviewed by legal and approved by the executive director on the basic legal parameters as to whether or not it meets all the criteria necessary. And we as a board should set those policies, give that direction, which I believe we've already done. I mean, I believe that at least all of the classes that I've seen, the outreach that I've seen, has a direct tie to the agency. There is a legal assessment that says it meets all the legal requirements, and all of the allocations has been approved by the executive director or his designee, which might even go down to the district administrator who actually makes these decisions. The presumption that board members are making the decisions, you know, the board members have a policy oversight influence, you know, and so that's where the restriction needs to be placed, in my opinion. And so I mean, 800,000. I don't know. I don't think the work has been done in order to justify one number or another. I don't think the criteria has been set in order to have the internal controls and the transparencies necessary in order to assure the public that this is legal, that these events are within certain requirements, and that they meet certain conditions. And I think that's where the agency, the board, as the policymakers, should go. Now, I could run off quite a bit of more history on this stuff as to the cost associated with it. Some of it we're currently still doing, so I agree with the controller. There needs to be continuity and consistency, because I believe the Taxpayers' Bill of Rights requires that. At some level there's some consistency in what we're telling our constituency and the benefit of the education that we're providing to the constituencies should be somewhat consistent throughout the board. And I believe that has occurred through evolution, because every district does the basic sales and use tax classes. Every district does the nonprofit classes. Every district, there are certain components that are just district-wide, statewide type activities. Some business resource seminars may be bigger than others, may provide more of a variety than others, but the basic fundamental premise and the foundational lesson that is taught or encouraged, if you will, is compliance with the sales and use tax laws and the other laws of the state of California. Let me just close, because I'm just basically saying we need to do the homework in order to provide the historical perspective and all of the facts so that people can make a decision about this. And the other thing that I think we might want to consider as an agency is we may want to consider reaching out to the Franchise Tax Board, EDD, the Insurance Commission, Internal Revenue, who all partner with the Board of Equalization in these events, and maybe entering into an MOU, because even though there are an extreme amount of efficiencies in what we currently do, in my mind, maybe they need to, because they participate and they benefit as well. Or we discontinue and we begin to educate them. The policy decision, at least the policy decision as I see, is that the Board of Equalization administers $61 billion in tax and revenue, of which 97+% is self-reported. And why does that occur? Well, it occurs for all the other reasons that things occur. You got enforcement and you have education. You take away education, well, there's a question as to whether or not the self-compliance is going to occur. We have almost, I don't know the number, but there's like 100,000, 500,000 new permittees opening up and operating every year who just have to be educated. If you looked at just the new permittees that are being educated, opening up over the next 6 months, you're almost talking about $2 in education per new permittee. I don't know what these numbers are. I do know that there should be a process by which we take a look at all the data, and this should be a board outreach plan, a statewide outreach plan that's been approved by legal, signed off by the administration. The board looks at it from a policy perspective.
Thank you. Let me just a couple of quick observations. You know, I get the idea that it should be a board. You know, that outreach is generally board driven. And I get that, and hopefully it is. But the reality is that we have unique board members who choose to reach out to their districts differently. I'll give you an example. I have a very big district. I choose to do mail. I did a mail to dealing with seniors on tax issues, property tax, and some other tax issues dealing with other aspects of tax that we deal with. I did a big mail. I got 40,000 responses from it. So I chose to reach out to people in that way, unique to my district, and I'm fine with that. But I chose not to do other things then. Other members have chosen to do specific seminars, like a port seminar or touching women with power, whatever those are. They chose to do that as their unique outreaches. I think that's good because it gives each member the unique ability for us to respond to our constituents how we think we need to do. On the other side of that, I do think we need parameters. I get the idea we want to be legal. Hopefully everything that we do is legal. But there is a finite amount of money out there. And so just the idea of just getting it being legal doesn't necessarily mean that we should be able to just do it. So I believe at least this is a first attempt to put some parameters together. I think it is an important time for us to do that. I think I especially then feel like the 6-month issue is good because then it gives us a really short time to come back and evaluate in order to see if we're going down the right track. So I do believe that there is a place for us to each be accountable to each other and to the organization and take responsibility there. So again, maybe other members do it differently, but when I say I think I need a seminar in Big Bear because we don't go there, that's me directing. I'm involved with that. Now I'm involved with it because I think it's the right place to go because my constituents, I believe, need to be touched there. So I am engaged in that process of help direct priorities in that way, and I think it's appropriate. So I'm very comfortable again with this as a first start, as a guideline. I think we need to find an amount of money. I don't know if this is the exact one. I think the way it was done was at least reasonable, looking back at the past and coming up with that number. So I think there's some. It wasn't just brought out of the air. There's some reasonableness as to how it was done. So. I would hate for us not to take action.
Well,
that would be my point. I think. Go ahead,
just
member.
A point of clarification. Let me be clear. I too acknowledge the uniqueness in the various different districts, and I think that the members' input should be part of that process. Certainly not the dominant factor. Is not you have to do it and so forth, but it's part of the process. The members, and I concur. With the efforts of a member runner because of his geographical district is so broad, which creates a different dynamics as it relates to being able to gather people together. And so, and have been supportive of that. But that is to the extent that we are providing our advice, to the extent that we're providing our input, as with the constituents in mind. I think that's a huge value to do that. What the dollar amount should be, I quite honestly don't know. I think that's a determinative factor based on what we've told the legislature we're going to spend outreach and education funds on. Because, I plan on doing some marijuana outreach and education that's not necessarily listed in this 6-month period of time, and maybe some use tax and some other stuff that is part of the BCPs. I'm supportive of it. I don't want anyone the members to believe that, one, this is not a start, but I believe it's just more of a process that needs to be established. Two, that the members are not involved in providing advice and input and direction. We should be involved. We're elected officials that represent 9 million individuals, more than 21 different senators, whose outreach and education effort of any other statewide agency that's in this process is just different, but the amount is still there. So it's a process that I'm recommending that has our input, and then based on that input of the members, if I may, Mr. Runner, just use your example, not to point it out, Big Bear In my case, what's that island? Channel Island? I need to go and do something over there. I haven't, but I recommend it. And here's the basis for it. I've got constituent complaints, constituent inquiries. I've got X number of taxpayers over there. I've got new permittees. It goes through this process, and this is what currently happens. I call up the department, make my recommendation. Department goes to legal. Legal makes an assessment. It's within governmental purpose. It meets the core values of the agency. Goes to the executive director. In fact, the executive director recently called and said, "Hey, Horton, there's a outreach effort in your district that is X amount. What do you think?" I said, "I think it's too high." He said, "Well, I think it's too high too, and I'm going to reject it." Well, he should have that prerogative, and because we've given him that authority. So that's I'm okay with starting somewhere. But I'm just suggesting that staff goes back and do the research, because at some point, someone other than the Board of Equalization is going to take a more in-depth look at these business sales and use tax classes, and you'll find that a lot of hours are allocated to those. A lot of time is allocated to that. And then there's outreach associated with that that's not included in the budget. Someone's going to take a look at the BCPs. Well, we've told the Department of Finance that we're going to do some outreach and education in this area, and it's not included in your outreach and education budget. So where did that money go? What did you do with that staff? And that whole reconciliation is going to take place at some point. And I'm just saying that this is a limited presentation to what the reality is, and we ought to allow staff the time to go back and do their due diligence to make that presentation, not only to the board, but also to the public.
Thank you, Mr. Chairman. First of all, I agree with you. I think we need some parameters established, and I mean, from my perspective, I think this construct is essential to be able to track our costs. I mean, it's been a problem. It's the subject of an audit. And I sure would like to think that this agency is the most accountable for taxpayer dollars. So I really think that having this construct is essential. Practically speaking, I think members do drive the outreach. I mean, you can't say that you don't. You know the needs in your district. You know where we need to be to educate taxpayers. And Ms. Harkey, just identifying where they've been underserved, I applaud you for putting your priority there, because we need to touch them. But you're identifying that for the outreach staff, and I do think members have a better pulse on where in their districts outreach may be the most effective. So I like the idea of having the allocation. It's something that can be easily tracked, frankly forces us to prioritize. I mean, I don't get any of this, but it forces my colleagues to prioritize. And I think there's just a better accountability all around with respect to the use of those dollars. Now, Mr. Horton raises some interesting points about other strategies that could be used, and I hope this is part of the whole evaluation of the effectiveness of what we're pursuing relative to outreach over time, and we build that into the evaluation. Are there better partnerships in which we can accomplish outreach? Are there new tools that need to be developed? We're not going to be able to get away from, I think, hard mail, because several of the members do represent remote areas of the state. So, part of the evaluation is looking at how do we do this better going forward. But we have to be able to be accountable for every dollar that we spend on outreach. And practically speaking, if we don't have an allocation per member and leave it up to the agency, you're all going to be directing the outreach staff in some way, whether it's just to identify an area where something may be needed, and it puts the priority then back on the staff, which I think is how we got into this debacle in the first place. So I think we need some parameters. They're well defined here. It's not to say this is what sticks in perpetuity, but it's a start. And I do hope that the evaluation can be robust in terms of really getting some metrics around effectiveness. Yeah. Attendance is a measure, but I'm not sure it's a measure of effectiveness. Yeah. And frankly, effectiveness is more long-term relative to compliance. Yeah. And I like the idea, because we used to do this, of bringing in other tax agencies and kind of doing a one-stop shop, where in some areas it might be a good idea to have them all the agencies represented and to provide education. So all kinds of options, but I think first and foremost, how are we going to be accountable for our outreach activities and the dollars associated with them. And I'm only suggesting that we do an even allocation short of being able to really hear on the dais, on the spot, identifying priorities in each district, but maybe through the evaluation process that can be informed as well going forward.
Is there a motion in there?
That is a motion. I do move that we, I guess it's a staff recommendation, right? And with the report back in May on the effectiveness of the program.
There a second?
I would second that, Madam Controller, but would also ask that the comprehensive report come back to the agency so that the agency has as much information as it can possibly have in order to be able to develop a comprehensive outreach that encompasses of the variables that I put forward.
And that will be the intent as our committee works with this to bring it back in May. That will be the intent of the committee. Okay, there's a motion, a second. Member Harkey.
I would just like to say one thing. I have no problem with allocating on a district, but I really hesitate to have it be Board Member Harkey's budget because I do not control it.
It's not a board budget.
So if it's, I have here in the thing a member budget. I would like to see a district budget if that's how we want to do it, rather than a member budget, because I don't control the funds. And you, as you said, David called you, you asked, I mean, this is all done without me. I merely go, my staff is out in the district, and they go, well, why don't we go down here, why don't we go there? And that's the extent of our involvement.
Yeah.
And if they have the budget for it, then they can facilitate it.
I think that's a good point, and I think in future, in reference to it and in the plan itself, if we can refer to it as a district allocation.
Yes, Mr. Chair.
Yes.
Okay.
That would make me very happy.
Okay.
That's fine.
Other discussion? Okay. Any objection?
Rule. Motion second.
Oh, the motion has been seconded, right?
Rule.
Okay.
Yes.
Okay.
And with the,
Reaction, all in favor of the motion? Any objection?
no.
Okay, motion carries.
Right, thank you.
Thank you.
Thank you.
Start.
Okay, I'll turn this back over, we will now adjourn this committee and turn it back over to the chair.
Okay, Ms. Richmond, next item is the taxpayer here yet?
The taxpayer is not here yet. Would you like to take up the legislative committee?
Is legislative committee here? Yes.
Yes.
Ms. Peelsticker is here. Let's,
So our next item for today is the legislative committee. Ms. Ma is the chair of that committee. Ms. Ma?
okay. Thank you. We will open up the legislative committee. And I see there's Ms. Peelsticker and a number of different representatives here. Mr. Gamper, are we doing the first item first? I-2?
Are you coming?
Or, Mr. Gamper, just sit. You can stay here. Okay, how's that? Anybody else wishing to give public comment, please come up, regardless of whether this is your bill number. How's that? Okay, Ms. Peelsticker.
Thank you. Michelle Peelsticker. Hello? Mike's
Hello?
Hello? There we go.
Hello.
Good morning, members of the board. Madam Chairwoman Michelle Peelsticker, here for the Legislative Committee. The first item is Suggestion 1-2, which involves an exclusion from change in ownership for certain family farm homesteads. I also have with me Ms. Rosemary Kinney, who is our property tax analyst and helped draft this proposal to answer any technical questions that I am unable to answer. The source of this proposal is Chairwoman Ma. Under existing law, Proposition 58 of 1986 enacted the parent-child change in ownership exclusion, and this exclusion applies to a principal residence, the first $1 million of full cash value of all other real property as well. Generally, the parent-child change in ownership exclusion does not apply to transfers of interest in legal entities, subject to 3 exceptions. 1, cooperative housing corporations, 2, resident-owned mobile home parks, and 3, resident-owned floating mobile home marinas. Therefore, as written, the law does not provide for an exclusion from change in ownership for family farm homesteads that are placed into corporations after the parent's purchase, where the stock in the corporation is transferred to the children upon the parent's death. Consequently, a family farm that includes the principal residence that is passed to the children via a transfer in stock in a corporation upon the parent's death will be reassessed to full market value. So the proposed law would exclude from change in ownership a parent-to-child transfer of stock in an eligible corporation that owns eligible property, provided the transfer is due to the death of a parent or parents. The proposed law defines eligible property as a parcel of land that includes the principal place of residence of the parents prior to their death, has been the continuous place of residence of the child's parents since the creation of the corporation, and where its full cash value on the date of death does not exceed $1 million. An eligible corporation is defined as a corporation that meets all of the following conditions. It was created prior to November 6, 1986. The only real property owned by the corporation is eligible property, and the only stockholders in the corporation have been the parents and their children. The proposed law also provides that any property reassessed in contravention of this new law, where the transfer occurred between January 1, 2014 and January 1, 2018, shall receive a reversal of the reassessment prospectively, with no refunds, upon application to the relevant county assessor. The revenue impact is identified on the agenda as less than $5,000 annually. I'd like to correct that and say that it's at least $5,000 annually, but likely to be insignificant. And that is based on the taxpayer that we were able to identify.
Okay. Mr. Gamper.
Madam Chair, members, John Gamper representing the California Farm Bureau Federation. My taxpayer and I were here in May of last year to testify before the Taxpayers Advocacy Committee, and we're very thankful for the drafting effort by Legislative Committee and the result of this very narrowly focused proposal that is essentially limited to my taxpayer in the situation where he and his sister had a transfer and ownership of 5,000 shares each from a corporation that was wholly owned by the parents. The president and the secretary were the husband and wife, and the transfer was to the son and daughter. And because they put it in a C Corp prior to the passage of Proposition 58, they were not entitled to the transfer. The skill of your staff in drafting this proposal is astounding, and I've never been more honored to be before you today to thank you for stepping up and taking care of this issue.
Any questions, members? Ms. Harkey.
Well, I hope you spread the word to all of those in the farming industry, right? No, I think it makes sense. I mean, it is very narrowly drafted, and we do have excellent staff.
Ms. Stowers.
I agree that it's a very narrowly drafted bill, and I definitely understand how the change of ownership resulted in an increase in the property tax assessment for the individual. However, I just want to let the members know that I'm going to be voting no on this item because we believe that the property tax rules and the change of ownership rules, all of that needs to be looked at comprehensively under tax reform. So it will be a no vote.
Okay. And I think, the purpose is to see where the members are and to get a legislative sponsor. I know that I had carried a bill to allow adopted kids to also be able to inherit property from their foster parent, and that went through the legislative process and through the review process. But obviously, it still has a 9-month at least process to go through to see how the legislature feels about this as well. Mr. Horton.
Thank you, Madam Chair. Conceptually, I'm sort of supportive of it. Conceptually, the inherent challenge that I have is I've always had a challenge retroactively changing something, modifying a methodology. And so it always causes me to sort of pause. I try to look at legislation from a double-edged sword perspective. And so theoretically, to go back and change something that would subsequently cause an increase in someone's tax liability would be concerning. A decrease would be exciting, but it's the retroactive component of it that gives me pause, and it's something I think the legislature, but I think the legislature ought to have an opportunity to take a look at it, and I'm hopeful that the votes are there to move it forward, but it just, for the individual, love to be able to do it for the individual. as a matter of policy of retroactively modifying, I don't know if we can do it yet, and not at the same time say, okay, you don't get a refund during those periods. So we're going to make it a right. We're going to modify it. We're going to say it was wrong, and then we're not going to give you the money back for those periods. It seems to be counterintuitive from a legislative perspective for me, but the legislature can do whatever it wants to do. But I would think, this is also sort of tied into Proposition 58, which modifying a proposition retroactively also gives me a little bit of pause. So, but I wish you well.
Mr. Runner.
I'd make a motion to sponsor the legislation.
I'll second.
Okay, why don't we, you know, I think last year, I think we established kind of a precedence of trying to get members to support unanimously for board-sponsored, or at least if a member was not comfortable with it, then they were okay voting no and being the no on the no. I'm not sensing that.
That's what I recall too, and that's what I was expecting, that for at least for control of you, it would reflect a no on the support letter.
So it would be individual board members.
Yeah.
Rather than the board approving.
Right. So I'm hearing that there's not unanimous support for moving this as a board-sponsored, but certainly I think there are 3 members who are going to be supportive and would add our names on as sponsors individually.
I'll withdraw the motion.
Yeah. So
Okay.
thank you for bringing it to us. I think it's important that any type of legislation that affects the BOE has a hearing here, just so you can kind of sense, you know, what may be the concerns here at the board. But, you know, for other members who are supportive, you know, we do continue to add our names either on the support or the opposed. So that's kind of where we are. But Mr.
Let me just ask a practical question, the difference in regards to then how our legislative staff engages. When it is that we have a majority of the board who has signed a letter of support versus a piece of legislation that we've voted to sponsor, how would the legislative division kind of handle that in front of the legislature?
If it's a support position, we would just testify on behalf of the board in support, but we wouldn't work the bill or try to find an author for the bill or anything like that.
Well, but I don't think we have either of that. I don't think there's a vote to support. It's just that you're going to end up with a letter of the majority of members who say, we're okay. Do you interpret that as then support?
No.
It's my understanding that you would all write individual letters.
Okay. So at that point then, if indeed we move forward with this kind of, and I'm just trying to get clear what our role is. So at that point then, you would then go and testify and ask any question, and be available to answer any questions that may come up from the legislature, from a BOE perspective, but not necessarily then present a position that the board would have.
That is correct.
Okay, thank you.
Great. Mr.
Thank you, Madam Chair.
Mr. Horton.
I don't know. I don't think this needs clarification, but I certainly would encourage that it's clear that majority of the members would support this, that the staff be supportive of those members and accomplishing the objectives that they seek to accomplish. What we have experienced in the past is a little bit of confusion over whether or not staff resources should be somewhat allocated. I think that can be allocated to the members themselves, and it should be, in order to, make sure that this gets its opportunity. One of the positions I've consistently held from a legislative perspective is my opinion should not be the end of the legislative process.
Madam Chairman, just to remind the committee that my taxpayer is of Japanese extraction and his grandparents were interned at Tule Lake. And so you'll be saying I'm that we will be correcting a wrong, shall we say, to 3 generations of Catos, one who was interned, one who tried to live on a farmstead and raise commodities in Yolo County, and intended only to transfer that farm to their children, and then to the children who have now been denied that exclusion of change of ownership simply because they were uninformed, and Howard believes, my taxpayer believes, that the website of the BOE actually misleads taxpayers to think that a trust will trump the transfer from a legal entity. That's how it appears on the website. That's how he was misled. And so we think that this really does correct a wrong to 3 generations of Catos, and it would be very wise for the state to do that, I think.
Yeah, I would share that. I wouldn't have been with the Board of Equalization if it wasn't for Mr. Cotto. Not the one in particular, but certainly related to some degree. He was my accounting instructor, and he was my reference to the Board of Equalization and why I came to work here.
Wow.
May I request clarification? So it is my understanding then that Chairwoman Ma, you will be responsible for sponsoring the legislation or finding an author, or?
I mean, I think it's up to the board members who are supporting legislation to go and try to find an author. So to the extent,
So the board has no position.
The board has no position.
And I would be there as
Right.
support staff to the extent that they
Right.
need technical support during.
Exactly. Like during the hearing, if they want to ask the board questions on how it impacts and why this happened, or the history of the legislation, you would show up and you would give the board report. But other than that, I mean, it'll be my office that'll work on a sponsor. We can work with other members. They can sign a letter of support and be on record of supporting the legislation. They can show up, or their members can show up and add on, testify, be a me too, like everybody else, but it's not a board-sponsored piece of legislation, right?
Okay. Thank you.
I believe we still have another speaker.
Yes.
Samantha Corbin on behalf of the California Tax Reform Association. I'll be brief, and we do appreciate the efforts made by staff in this proposal to create a very narrow exemption to law. But unfortunately, if the board was to move forward with legislation on this issue, we'd likely oppose. We definitely reflect some of the comments of both Mr. Horton as well as Ms. Stowers, and are concerned about reopening conversation on transfers about corporate shares on the whole without really looking at the whole issue holistically. We would oppose any new exemptions absent a much larger conversation on the issue of property tax.
Okay. Thank you. Okay, so you kind of know where the challenges are. All right. Thank you very much. Ms. Pielsticker, the next item?
Yes, our next proposal is suggestion 2.3 related to cash basis reporting. The source is Honorable Fiona Ma. Under existing law, retailers are authorized to add sales tax reimbursement to the sales price of property sold to a purchaser under the terms of a sale agreement. A sale occurs when the seller completes performance with respect to the delivery of the goods sold. For purposes of the sales tax, a return must show the seller's gross receipts during the preceding reporting period, and gross receipts include the total amount, the total sale or lease amount, or rental price of a retailer's retail sales valued in money, whether received in money or otherwise. The total sale or lease amount or rental price includes receipts, cash credits, and property of any kind. Therefore, sales tax payment must be made on an accrual basis and is required to be reported and paid with return for the period in which the sale occurs, even if the retailer has not received payment, full payment, I should say. Under the proposed law, retailers would be able to elect to report their tax on a cash reporting basis. Revenue impact is about $265,000 per year, and that reflects lost interest in the BOE's bank account. I have here Sheila Waters, who is the sales tax analyst who drafted this proposal, and she can assist in answering any questions as well.
Nothing to add? Okay, so I think this stems from an actual case, and many cases that come before us. Small business owners, the mom and pops, I mean, they just keep their books on a cash basis. They pay their taxes, on a cash basis, and under the regulations, maybe you can correct me, it says that the board is supposed to look at taxpayers on an accrual basis for sales tax purposes.
Correct. That's correct.
Right. And so what we have found in these cases is that most of the time the board does look at a taxpayer's books and records based on the way they keep it, but there are some exceptions where they decide they want to apply the accrual basis accounting to capture some sort of tax or statute of limitations to open it up. And we don't really feel like that is fair, that we should, go with the taxpayer's books and records and not force them to adjust or hire an extra accountant to be able to come here and testify or be able to defend themselves if they don't keep their books on an accrual basis. And that's the reality with many small businesses. So that's the reason I'm sponsoring this legislation, and I just want to make sure that these smaller mom-and-pop taxpayers, aren't subject to keeping a separate set of books, especially when they're getting audited by us. Ms. Harkey?
Okay, I have some questions. My staff looked at this and initially thought it was really a great idea because we share your concerns, but I guess I have some questions. The number one question is how the cities and counties feel about this. Will they be impacted as to their revenue stream? Next thing is if something is sold like on an installment basis, like 36-month term with monthly payments, how does that work? Because they're not getting the money in right away, so do we in essence finance their installment sales? Believe me, my staff noodled on this a lot, and so I just have some real basic questions. I think that the intent is really good, and I'd like to find a way to accommodate what we do see here at the board. I'm just having, once I start actually implementing this practically from an audit perspective, I'm just, and from a receiving the tax revenues, I'm just questioning as to how all that works out.
Sheila Waters. There could be a delay in capturing sales tax receipts to the extent that there's long-term financing contracts out there. We weren't able to measure the extent of those to really associate a sales tax receipt, actual receipts delaying over the fiscal year. So, for example, we might capture a portion of a 3-year contract within the first fiscal year after enactment of this bill, but there could be a delay because we wouldn't have had the 2 other years' worth of sales tax revenues. So I guess there could be a delay from fiscal year for local jurisdictions.
What would happen if, in fact, the contract didn't fulfill, and so then it's the items repossessed, we don't get the sales tax. Usually we get the sales tax up front, and it's up to them to finance however. I think that's something that really needs to be ironed out here before I'd be really comfortable. I think the intent's good, but I don't want to be financing or delaying our sales tax revenue based on a contract. I think it's going to get real messy, and we'll have more cases up here. But these are, I think, like I said, we see a lot of folks that we really do need to assist and allow them to keep their books and records the way they keep their books and records. But I think we might be getting into some, and if we can just narrow it, it'd be fine, because I don't think the cities and counties would really be affected. But I think if we start financing term sales, installment sales, I think we'd have a problem.
Mr. Renner.
Yeah, I think the concept is good. We too kind of have a couple of questions on the detail. So we'd be glad to kind of continue to have dialogue and maybe bring it back in the next upcoming month, and we can help kind of resolve some of those. That would be great. But I think conceptually, I think it's a convenient opportunity for taxpayers.
Ms. Towers.
I do agree that the concept is good, but the details, and one of the things that I was concerned with, if the taxpayer does make that election to report on a cash basis, that's going to be additional record keeping on their part. to know when they got the payment based on the way it was written. So once that payment is received, then they have to submit the taxes. And I'm just seeing an audit and trying to reconcile when payments were received, when was tax due, and just added compliance burden on them. And that's the last thing that we would want, is to increase the burden and to increase the tax liability. So I would like to see a little bit more study on it to see how it would actually work. And also, if it is the election per return, or would the taxpayer be required to make the election, and once the election is made, it's permanent? You know, just a little bit more work here would be very helpful.
Mr. Horn?
Thank you, Madam Chair. The whole cash reporting thing is problematic for large retailers that are selling equipment of that nature. We've had a couple of audits where the taxpayer records are on a cash basis, but they reported on an accrual basis, and that they were audited on an accrual basis on a cash basis instead of accrual basis. So it kind of got all mixed up and ended up with a liability. At the end of the day, it ended up with a wash, which is what happens with cash and accrue. It ends up washing itself out. And so maybe there's some work that we can do on the audit side to assure that taxpayers who are or want to keep their records on a cash basis, one, can, because I think the Supreme Court has made it clear that we can't dictate to them what kind of records they have to keep. And the accrual method is tied into the fact that California is a transactional tax. Sales tax is a transactional tax, and that's just tied into when the transaction occurs, that's when the liability theoretically is due. But we have another provision that says, well, you don't have to report it until you actually file it, because sales tax is not held in trust. And so those two laws sort of conflict each other. They end up, the sale could take place in January and not really get reported to us until April. So there's that delay. So I did have some concern if everyone had to do this, because a lot of taxpayers actually like to have that float, if you will, of that 3-month float and reporting it, because sales tax is not considered at this point. Something's held in trust. I would encourage the agency to take a look at the potential loss as it relates to the interest calculation, on not only the interest calculation on just the reporting, but also the interest calculation on any audit liability that may be out there as they continue to sort of consider this.
Okay, so thank you, members. So we will continue to work on this and bring it back for further review after we've been able to answer some of these questions and maybe tightened it up a little bit. Okay, thank you all. Any more items, Ms. Richmond, for the Ledge Committee?
That's it.
Okay, so we will adjourn the Ledge Committee and go back to regular session. Is our taxpayer here yet?
Our taxpayer has signed in.
All right, let's call the next item then.
So our next item is C7A, Green Apple Inc., and C7B, Cravery Northern California Inc. Please come forward.
Thank you.
There's going to be referring to this chart, and it doesn't change anything.
Okay.
But they're going to be.
Thank you.
Thank you. Green apple right now. I'm hungry.
Yes, getting that done.
Okay, I think we're all ready. So, Mr. Noble, please introduce the issues in this case.
Good morning, Madam Chair and members. I am Jarrett Noble on behalf of the Appeals Division. The appeal before you presents one unresolved issue, which is whether relief is warranted based on petitioner's reliance on incorrect oral and written advice from the board. In addition, the department has one revised recommendation, which is to reduce the measure of tax for Green Apple Incorporated by $11,556.
Excuse me, one more time?
reduce the measure of tax for Green Apple Incorporated by $11,556.
That was the measure, not the liability.
The measure, yes.
Okay. Okay, Ms. Wong, welcome. Please introduce yourself for the record. You will have 10 minutes.
Yes.
You don't have to use the complete 10 minutes, and the state will present for 10 minutes, and then you'll have an additional 5 minutes, and then it'll be open to the board for discussion.
So I believe each of the board member will have a copy of all this information. So I try not to take too much of your time. I just newly submit a timeline. So it's just like to briefly give you an idea of the whole case. So start from December 2007, before I was open 2 stores. One is Green Apple Inc. Green Apple Inc. was actually holding Ice Bee yogurt. So it's like a yogurt store. It has seating, and then it takes about over 1,000 square foot. I took the floor plan for both places. It's actually sharing one space. The Cravery Northern California was a franchise, so that's the reason why I wanted to keep the books separately. So I had to incorporation, because I have to report to the franchise board and submit those, franchise fee. So for the Cravery, there's no seating, and there was only selling pies, like drinks and others. We have sold some salads and stuff. So I bought the plan to the floor plan and everything that I have to the Board of Equalization in San Francisco, and I was applying 2 permits, as you see in that chart. I submit 2 permits application, but the Green Apple one was accepted because it has seating, and the Cravery was denied. There was mainly 2 reasons. They say first is it's a pie store, so you're not selling a real meal. So, and then the second reason is because there's no seating. So as a test player, I can only accept what I was being told at that point. So on February 2008, I opened Green Apple. I used the register on both places to collect sales, either credit card or cash. So we're keeping a good record of what needs to be charged to the customer on sales tax and everything. For the Cravery, because I didn't have a permit, and I don't believe it's legal to collect sales tax for no reason. I cannot keep it. I have to give it to a Board of Equalization. But then where do I give if I don't have a sales permit? So meaning that I could not collect sales tax from the customer. That was my understanding. And the Cravery, for your reference, is December 23rd, 2007. It was the first day it opened. But then on February 2008, while I start opening Ice Bee frozen yogurt, and I start worried because I keep collecting tax for each transaction for Ice Bee. I felt that was the right way of doing it. So I submit to the Board of Equalization every quarter once I receive, the bill. So not the bill, but every time I need to report it, right? So I submit the sales tax. I felt that's easier for me as a tax player. So I went back to the Board of Equalization in San Francisco again and requested a sales permit the second time. But then they told me the exact same thing. No need to collect tax. You have a pie shop. So on March 2008, I wasn't feeling comfortable about this because my friend was telling me, are you sure? And then I'm like, yeah, they was telling me. So I call again. I make a phone call to the San Francisco Board of Equalization. I spoke to Dorothy Richardson, and from what I know, she was the supervisor. She told me that, no, you don't need a sales permit. But then I said, well, is that somehow I can have a written confirmation? She said, yeah, just go ahead and send a fax to me. So she provided that fax number. And then I sent her a fax, and I remember on the same day or a day after, I received a fax copy. So that was actually my fault because I could not find the fax copy because I tried to keep it in a safe place, but I just couldn't able to find it. But I do have it, so there's no way I will throw it away. So that's the reason why it brought me here, basically, because I couldn't find that written copy. On September 2009, I went to the Board of Equalization the third time. The reason behind it is because at that time there was someone interested in opening a second location for Cravery Pie. So I went ahead and asked, because if I'm having two locations, I better be clear what's happening and what I need to be done as a test player. So I went ahead and then explained the situation. There's a potential location. I showed them the address and everything. So then finally they say, okay, I remember it was the supervisor told me, okay, you can have this permit, but remember, this permit is only used to collect tax for combo and soda drinks. If, as a test player, I would not make this up because it was so clear the instruction was given. So the first minute when I got the tax permit number, when I went back to the store, I told all my employees that this is what you need to do. And I changed the register right away at the same day to collect tax for combo and soda drinks. So on January 2010, that was what you will see why ISB or Green Apple Inc. was getting involved, but because the whole franchise for Cravery it didn't work out. So we, as a franchisee, we no longer need to submit any franchise. It was the whole relationship was broken. So that's why for my accountant was advising me, in fact, I can use Green Apple Inc. as the incorporation and holding two businesses that will save me $800 per year because I no longer need to report to my franchise fee. So I thought, oh, that's a good idea. So that's the reason why I picked January 2010 because I believe maybe not that exactly day I went in, but then it started from January 2010. I probably went in on December sometime and then saying that, oh, this is the change. So I explained it to the Board of Equalization's member. And then they say, okay, then you start using this new number. So they gave me, I think the same day, they gave me a new number. They say, starting from today, you should use this new number to collect both taxes from Cravery and ISB, which is Green Apple, right? And then you start combining those tax and file it every month. So that's about it, what I wanted to say. But one thing I want to say is, as a test player, I believe, and I totally think I was doing the right thing. I tried so many times, not just calling, but physically going into the Board of Equalization, believing the government is promising the right thing. I don't think I did anything wrong to be assessed this tax. And I did not collect any of this tax for the customer, not because I didn't want to, it's because I have no right. And it was illegal to collect any sales tax without a sales permit. So the sales permit is the first thing I need to collect. And then if you look at September 2009, once I got my sales permit for Cravery, I start collecting it. And who make it up for combo and soda? Surely it wasn't me. So I mean, that's something that we should think about it, and that's the reason why up till now, I still searching for the letter, and also up till now, I still 100% totally believe I didn't do anything wrong to not collect the tax. Thank you very much.
Okay, thank you. Department, please introduce yourself. 10 minutes for your presentation.
Good morning, Chairman Ma, or noon, maybe.
Yes.
Don't say that too often, but Chairman Ma and members. My name is Scott Lambert. I'm representing the Sales and Use Tax Department today, or the Business Tax and Fee Department. To my right is Kevin Hanks, also with the Business Tax and Fee Department, and to his right is Stephen Smith with the Legal Department. In this particular case, the taxpayer operated two businesses that were next to each other. One was a yogurt shop, and the taxpayer had collected tax on all sales from the yogurt shop during this audit period and reported them. The department looked at the records for that location and accepted them. They appeared to be accurate. So the only issue was the Cravery, which was located next door. The Cravery sold various different items. It was not a bakery, and that's maybe where some of the issue comes from, is a description of it as a bakery. What it sells are pot pies, and if you, growing up, anyway, I think most of us ate frozen pot pies. That's similar to what it is. There are various types of those, but in essence, it's a little bit different than the pot pies in the fact that these pies can be eaten without utensils. So the crust is strong enough where you can hold it in your hand with, comes in a little paper container, and it's also in a clamshell container that's over that, and it's easily portable. So that's the main thing that the taxpayer sells. But there's also a number of other items that the taxpayer sells that may not have been described. They include soup, sliders, hot sandwiches, crepes, soda, combination meals, and the combination meals always have a hot pot pie. And there was also a sign that had seating next door, which was available in the ice bee. So the department determined that the sales made from the Cravery were of a taxable nature. An observation test was performed. Based on that observation test, a little over 85% of the items were considered to be hot items or taxable items, and of those, over 80% were considered to be food, and the department considered the taxpayer to fall under the 80-80 percentage or rule where all sales would be subject to tax. So the taxpayer is claiming that they don't owe any tax under Section 6596 of the Sales and Use Tax Law, excusable delay, reliance on advice. There's two things that are, well, there's multiple things, but there's two things in particular that you need to have in order to show that the department gave you incorrect advice. One of them is a letter sent into the department that fully explains your business, and then the response from the department that tells you that you don't need to charge tax on items. Based on the letter that was presented by the taxpayer, and it was the last item at the back of the summary DNR, there's a letter dated March 28th, 2008. The department feels that, one, there's no evidence that we received this fax letter. There's no evidence that the department responded to that letter. So There are procedures that the department goes through when they receive these taxpayer inquiry letters, and it goes through an extensive review process, and they keep a log, and then the letter that is sent back is kept in a locked file cabinet. There was no indication or no evidence that a response had been made or that we had received that faxed letter. The taxpayer also said that a fax was returned to them by the department within 2 days. And it's a minor issue, but the taxpayer did send or faxed in on a Friday. And that, as I said, there was no evidence that we received that faxed letter. So if you look at the letter itself, it doesn't explain the true nature of the taxpayer's business. It kind of refers to itself as a bakery. Based on this letter, you really could not give a reply. It's a difference whether the item sold is hot or cold. So if in fact everything you sold was a bakery item and it was to go, you should not have a permit. You're not required to hold a permit. There's nothing that you sold that would necessarily be taxable. If you are selling a hot food item, or let's say the pot pie, all of them you sold, there was no heating of those pies, and you just sold those pies to go, you would not be required to hold a permit for that either. Those strictly food. What makes it taxable is the heating of that particular item. It's the same thing with the soup, the sliders, the hot sandwiches, the crepes. Soda in and of itself, you would be required to hold a permit. So even if you were a bakery and you were selling soda, you're required to hold a permit for that. Anytime there's a combination meal, if one of the items is hot, it's sold for a single price, that's a taxable transaction even if it is to go, and you would be required to charge tax on that. So the letter that is being written here is really incomplete to describe what type of business was taking place. And as I mentioned, part of 6596 is to provide the department's response. If there was a response, and it's highly unlikely that it went through the review process, if there is a response, a taxpayer is required to provide that. At this point, there's no telling as to if there was a response, whether or what was said in that response. The one item, pretty much the submission or exhibit that's been provided by the taxpayer, the dates appear to be accurate. Two things I would point out is some of these we're not sure exactly what was said between the department employees and the taxpayer. I would point out Dorothy Richardson was not a supervisor. She was a tax tech that had been there for a limited period of time under March of 2008. It would not be the type of person that would respond to a taxpayer inquiry letter. On January of 2010, there was not a new number that was provided for the Cravery. The number that was used was the existing number for the Green Apple. So, in terms of the department did recommend a reduction of $11,556, and how we arrived at that was using all the information for the Cravery that we had. We did have the majority of their POS records. We accepted those. We had to estimate basically 3/4 worth of sales, and we used a method that is acceptable, but I believe the method that we're using now is more accurate in that we're taking all the POS, dividing it by the number of months, and using the average monthly sales to determine the audited taxable measure for those missing periods. So accordingly, with that adjustment, the department concurs with the Appeals Division decision and recommendation.
Okay. Ms. Wong, you have 5 minutes on your rebuttal.
Yeah, so as you guys may know or may not know, a business originally was really selling pot pie only. But since things can change, like we did not have seating, like what I said initially, but things can change over the year. As long as you can imagine, 2007 up to 2011, or even a few years ago, the recession and everything business was tough. So the slider and the hot sandwich, like this gentleman just mentioned, I think it was like after 2011 or 2012. I don't have a very clear memories when did we started, but before we have the permit, I can say we did not have the slider, we did not have the crepe and everything. And for the number that he mentioned that there's no new number, I apologize on that because it was a few years ago, but I remember I received a brand new permit. Whether the number is the same, I don't remember, but it's like a brand new permit. It says ISB/Cravery. So that's what I put up in my store, and start from that day, I collecting tax with that sales permit. So that's what I really want to emphasize. And for the information given, yes, I thought Dorothy was the supervisor for sure, and I did not know why there was no record, but the fax was received either on the same day or within those days, like what I first mentioned. And I remember it was 3 p.m. I remember I sent out something at 1 p.m., and then I received it at 3, because I was sitting right next to the fax machine waiting, because I was sharing the line with my phone and the fax, those days. So what I want to declare is everything I said is true. And what I did, I believe I was correct, and that was it. I didn't say anything that that is not the truth. That's what I'm trying to say. Thank you.
Okay, members? Ms. Harkey.
This is a real tough case because I can understand the confusion. When I'm reading here, it says that it was the permit said they were pies to go. And I believe the taxpayer said that they were, it says type of item sold on the permit is a meat pie sold to go only. And they are like a bakery shop. No indication of hot food, but unless you're really involved in the industry, you probably don't know that makes a distinction. I didn't know that till I got sitting up here and you guys educated me, hot or cold. If I have a cold sandwich, I'm good. If I have a hot sandwich, then there's sales tax, which I think is very confusing. I wish we could change that somehow, make it consistent. Because it's just, it requires the people that open up a business to go through, who would know? I didn't know. Anyway, so I have a lot of sympathy for that. And I'm wondering, I do believe she's very credible. The taxpayer is very credible in her explanation, and if you look at her flow chart. And I'm wondering, I know the department has made some concessions on stuff, but I'm just wondering if there's, I guess for the taxpayer, I'd like to ask you, when did you say you began to serve other items other than your pot pie?
I would say it's probably after I received the combo. So like what I said, then combo, if every time, like this gentleman said, the combo come with the pie, which is hot, then we would have collected tax after that, right? So I would not be able to collect any tax before that. And I can look up and see when we start introducing those, but I totally believe it's after 2010.
So that's for the Cravery
Yes.
only, right?
Yes.
The Cravery only. So I'm wondering, because we've got two cases here. We've got Green Apple liability, we've got Cravery.
Yeah, because the Green Apple is because after 2010, the sales permit was for both. So the Green Apple, I pay everything for the ice beer yogurt part, like what they reported to you, that I pay everything, and they already reviewed it very well. They had no question about that. But then why the Green Apple involved, it was because of 2010, I combined those under one corporation. So mainly all this tax they were chasing back is just for the Cravery pie.
Okay, so let me ask the department. I've got two liabilities here, Green Apple Inc. and Cravery. Green Apple is audit period 10/108 to 9/30/11. Is that combos or no?
Well, I'll explain. We can take the Green Apple out of it. That's the yogurt shop. That's okay. And I'll explain how it gets a little bit confusing. In the early part of the audit period from October of 2008 to September 20th of 2009, the Cravery was operating, but it did not have a seller's permit. Okay. And so when we went back to establish the liability, it went under the Green Apple.
Okay.
Starting on September 21st of 2009, the taxpayer got a separate permit for the Cravery. And so that's the only liability up through December 31st of 2010. On January of 2011, the taxpayer closed out the Cravery Northern California Inc. permit and then started reporting the Cravery back again under the Green Apple. So all this liability is for the Cravery location, but there's different owners for that time period. So when you're seeing the Green Apple liability, it's only for the Cravery, but it was during the time that the Green Apple owned it.
Okay, I'm kind of looking that maybe there is something we can do with any liability prior to 2010, because I do believe, I mean, I know this is not written advice, but I mean, this is truly very, very detailed. She's very, very forthcoming, and I'm thinking if we could do something, just maybe assess a liability from January 2010 forward or something, because I hate to go all the way back, because it looks like, I mean, we don't have an exact day of when she, January 2010, actually, that's the date that she says she got her permit, another permit. So she closed Cravery Northern California and then put everything under the Green Apple. I don't know, I just feel like some of this needs to go away, and I'm not sure how to really work on that. I feel like I believe this taxpayer really did try to do her job. It'd be different if she collected it and stashed it somewhere and just not remitted it, but she hasn't collected it, and I don't see that she's in the position probably to remit it. It's a lot of money, so I'm just trying to find a way. One day, I think it was a one-day observation test that was used to invoke the 80/80 rule.
That's correct.
Yeah, is there any wiggle room on that?
Well, it was for the entire day that they were open. It was a Thursday. It was in January of 2012. The sales for that day were, in total from the Cravery, were, I want to use the word equal, but that's not the right word, but representative of the POS data that they gave us for average daily sales. So that day appeared to be a typical type of sales day that they had. And like I said, the majority of their sales are the pie sales. So, as far as this is a franchise, and I can't tell you what exactly was being sold in the earlier periods, but based on Yelp, it was not just the pie. There were other things that were being mentioned in the earlier period. So,
I understand that. I think she says that when the recession hit, she had to get versatile so she could keep the doors open. I think that is probably what happened. I think she's very, very credible, so I'm just trying to find some creative way to get a break here. Anyway.
Do you have any ideas, Mr.? Okay, Ms. Dowers.
So the department, so the observation test was January 2012? And that's when you concluded that the 80/80 rule applied and makes everything taxable?
Based on that test, yes.
Yes. And because she was selling in 2012 the hot pies and other taxable items?
Right, right. So the type of non-taxable items that she would have would be, there's some cold sandwiches, there are salads, and then there's also cookies. And I believe that's the extent of it. A lot of times with the salads, there'll be a combination, and so it'll be sold as one price for a hot pie and a salad at that time.
Okay.
But the majority of them are hot pies, and that is originally what they started selling was the hot pies.
Really? I was going to ask Ms. Wong, when did you start selling the hot pies?
The Popeyes?
The Popeyes, yes.
The Popeyes start from the very beginning.
Oh, from the very beginning.
Yeah, so it's our major.
That was your major?
Yeah.
Well, that's where I thought we had some relief.
Were they hot or cold?
They are hot.
They were saying, I was thinking she didn't start selling them
And
until
I did
2010.
explain to them that I have a bakery and I'm selling meat inside and it's hot.
Yeah, she did say that in her permit was meat.
Yeah.
Yeah.
So, I mean, the fact that somebody thought it was maybe a pastry or a bakery item, I think is a problem.
Yeah, and the no seating part is like we always say no seating, but the thing is like customer keeps saying, oh, is there seating? Is there seating? Then my employees start putting a sign. I mean, instead of them keep coming in and ask, they just put a sign says seating next door. What can I do?
Do you know when you put that sign up?
Yeah, so I believe it's like around 2010. So at the beginning, we didn't have a sign. It was all the recession, we're trying to just put this company in a hole, just to try to survive. So whatever customer asks, we just try to, accommodate.
So if she didn't have seating prior to 2010, would the 80/80 rule apply?
It would change things because obviously if you take a cold food item and bring it to the seating that's made available, it would make it subject to tax. What I would point out, at least during our observation test, there were just 15% of customers used the seating, and in none of those circumstances did it cause a non-taxable item to become taxable.
And just kind of walk me through. So no tax obviously was collected whatsoever.
Well, that's not.
I mean,
no.
for the ones that you're looking at.
Right. They did report tax, and it started when they got the permit for the Cravery. And what they started reporting tax on were soda sales and combined combination meals. And they reported those as taxable, and they were given credit in the audit for that. But that's the extent of what they reported as taxable.
So are the corporations, the businesses still conducting there?
No.
And these are corporate liabilities?
Yes.
So if relief is not, if we can't find relief, they will be candidates for offering compromise?
Right. Yeah. That's my understanding of it.
When did, can I ask, what's the date that they got this new combo, new number that she's talking about in 2010?
I'm not sure. There wasn't a new number obtained in 2010.
So she said that she went to the BOE office, they gave her a permit, and the name changed.
Are you referring to January of 2010? That's
Yes.
on the.
Yes.
Yeah. So what that was is she had separate permits in December of 2009. She just had it should be January of 2011, but.
Sorry.
Yeah. What she was referring to is January 2011, but I'll explain that. She had two separate permits before January of 2011, one for Green Apple and one for the Cravery. The Cravery Corporation closed out, and then Green Apple took over the Cravery location and reported both under Green Apple's seller's permit. So there was no new seller's permit. It was an existing permit, but then what she's referring to is she got the new
Name change.
for the wall. You know, you'll come in and you'll see the permit on the wall. That's what they printed up, and they changed that to add the Cravery on there, but there was no new permit in and of itself.
But the new permit said what? What was the latest permit?
Well, the existing permit, which was the Green Apple, on there was written in January of 2011. It said Green Apple / the Cravery, and it covered both of those locations.
Okay, and so she shut down one, she shut down the Cravery permit, and then the BOE just combined the two locations. She had two locations open still?
They were right next to each other. In fact, they were connected. And yes, they were considered separate locations, and they went under the existing Green Apple permit starting in January of 2011.
Okay. Mr. Renner?
Yeah, just, yeah, it's a perplexing issue. Clearly, the taxpayer had an ongoing history of compliance when the law was understood with the neighboring business. And so I'm kind of perplexed as to, these are confusing issues at times. It gets more confusing when there potentially could be a letter request regards to taking a look at the bakery and what they're doing, how that was sent or lost, or I guess I have no reason to doubt that she sent it. I wish, now whether it was received, I guess we don't know for sure. We have no history of that, which would be typically what we would have, but I would have no doubt that she was trying in multiple ways and multiple times try to clarify the law and find herself in compliance.
Dorothy Richardson.
Tell me about Dorothy Richardson.
I have an understanding that I just received earlier. My understanding is that she worked for a short period of time as a tax tech in the San Francisco district office.
Okay. And why did to the taxpayer, why did you copy her on this?
Yeah, I have, because I find, because I call, that was the person that, no, not the first person I spoke to. Then they say, oh, yeah, wait a minute, I have to transfer you to a supervisor or something.
Yeah.
So then she told me that, oh, okay, you can send a fax to us. Then I'm like, oh, should I CC to you? So I've written her name and her fax number.
Yeah, okay, so clearly, again, this, sometimes we get documents, we wonder if they were changed around, right? Clearly, this would be a document that would seem to be authentic. There'd be no reason to figure out and come up with a name to CC that was only there for a short time, especially. So clearly, this is a document that was done at that time with the intent of trying to find the issue. Let me ask, the issue of us, of the ability for us to then make a decision based upon, under the taxpayer swearing under penalty of perjury that she received advice, obviously isn't as good as having that piece of paper. But what is the significance if she indeed, under penalty of perjury, identified the fact that she had received that advice?
Well, she's stated under penalty of perjury that she has received the advice already. I would note that there is an alleged response, that the board is the finder of fact here. So if you find her credible, the board is the finder of fact.
And so we could find, in fact, because of her swearing under penalty of perjury, that did come back. That would be the finding of fact that we could make the decision on?
Yes.
Okay. In that case, I would find for the taxpayer. Make a motion for the taxpayer.
Second.
Comment, Madam Chair.
Mr. Horton.
Members, I think that was I'm sympathetic as well, and believe something happened. I don't know what it was, but setting a dangerous precedent of having a taxpayer under the penalty of perjury say we received written advice, therefore you ought to overturn any tax liability. Well, quite a few taxpayers have come forth and provide that penalty of perjury document because it has no standing, there's no liability for them doing so. But
I agree. I think the thing that compels me is I believe that at this point the taxpayer is truly representing herself in the situation correctly and has other documentation. So I agree. I don't think it's a green light for anybody to come forward. They still have to be able to provide enough testimony and example in what they're doing and how they've exercised their business in the past. Again, a business next door. It gives me credibility to do it.
I mean, I'm going to stretch it, but I don't want to put words in the taxpayer's mouth, but maybe, did you receive written advice from the Board of Equalization, but you may have lost it, or may have?
Yeah, so it's like in this part, what I said, fax copy, still searching. It was from Dollar Free Richardson, and the reason why I remember her name is because from this original letter.
Without going too much further, did you have an opportunity to review that written advice you received from the Board of Equalization?
No, because after I received it, I told my husband I got it, and he said, "Oh, please put it in a safe place," which I did, and I couldn't find it because it's too safe. And then after the, 2011 or 12, yeah.
Do you believe the decisions you made was pursuant to the written advice you received from the Board of Equalization?
Yes, both written and verbal advice.
Okay. And the department, you have no record of sending written advice?
That's correct. There's a log that's maintained. There was no record in the log. There's also a copy of the letter that's kept in a locked file cabinet. We try to get them out pretty fast, but 2 days is not generally how fast they come out because of the fact it needs to be reviewed when it is something that is in the taxpayer's favor. If it's something where we come back taxable, then it'll be reviewed, but it doesn't necessarily go through the same scrutiny as that. And the other thing is, which may be very important, is they cannot recall responding to a letter by fax. That's not what the department, not what their standard procedure is, and they don't recall ever doing that. So
Richardson's not here anymore.
Question.
And the log, I was just going to add, Mr. Horton, in the log that the district maintains, and they do have taxpayer letters that they've written in response to questions that have been posed by taxpayers. And generally, those responses are in letter form, so ordinarily we wouldn't be sending advice letters via fax, so that's a different scenario for us as well.
Good. Well, The challenge is that both documents have to be clear and explicit in order for it to be, fall under the legal requirements. The question has to be clear and explicit. We don't have that. The response has to be clear and specific. This is a franchise?
That's correct.
How large of a franchise or do we have?
You know, I'm not particularly sure. All I can tell you is the information that I've gleaned from our computer system and from the internet. They don't appear to be active now, but there were a number of franchises that appeared to have permits and were...
Any evidence why the permit was issued in the first place?
For there, I did not look at the applications for the other taxpayers.
Any information provided when the permit was originally issued? They check off the compliance, little box they check off, we can provide this and this and that?
Right. I did not check the other franchisees' permits.
No, the franchisee before us.
Oh, before us?
Yeah.
Oh, I'm sorry, the question again?
The taxpayer operates the franchise.
Yes.
When they came in to fill out to request a permit, they were issued a sales and use tax permit.
That's right.
Presumably because whoever issued it presumed that there was a tax liability.
That there were
potential
selling
for
taxable
tax
transactions. Yeah, that's correct.
Did they provide them with any documentation to educate them on?
Oh, they were, at the time that they took out the original permit, which was for Green Apple, they were given pamphlet 22, which is the dining and beverage industry. So they would have received that at the time that the initial Green Apple permit was issued.
All right. Well, that makes it tougher. The board can't overturn itself, even in a written advice.
I have one more question.
All right. Well, members, this is indicative of the reason why we need new business education outreach seminars, a whole lot of them. Anyway,
Can I ask
thank you,
the department, how come you only did a one-day observation test? I thought we were supposed to do 3 days.
Well, at the time that this was performed was different rules at that particular time. It was in 2012, January of 2012. It was before we came up with the 3-day rule. But at the requirements at that time were generally to do several days of testing, is what the directions were at that particular time. And I think the issue there was more this 6596 issue instead of the 1 day. And we did the 1-day test. It appeared to be representative. The taxpayer didn't argue against it, and that's why it was left at 1 day. That was not uncommon before we took the new rules that came into effect here just recently.
So when did you adopt a new rule?
I believe, I'm going to say it was after January 2015, but I can't recall off the top of my head the exact date of that. Maybe.
I don't remember seeing or hearing that you guys were adopting a new rule.
We did under business practice.
Oh, you guys did?
So October 28th of 2015 is when we came out with new observation test rules that
that's
discuss a
mandatory?
3-day test.
So quick.
So mandatory 3 days now?
It is if we're using an observation test to determine what taxable sales should be. In this case, we didn't do that. We didn't have to use an observation test per se to determine what total sales were because we relied on the taxpayer's records for that information.
Okay, so the tax as determined is based on the taxpayer's records?
Yeah.
And not,
That's correct. Well, for the most part, there are 3 quarters where there's an estimate based on their own records, but for the most part, it is their records, actual.
Ms. Harkey?
Are hot bakery items to-go taxable?
Bakery items, no.
Hot?
Okay.
I thought hot food. is
Hot bakery
taxed.
items are not. And she
No.
thought she had a bakery, and she also thought that they were to-go. She didn't have seating. This is turning on the head of a pin, and she, I believe her. I think she really tried to get the advice right. So, she thought she had a hot bakery item,
Yeah, I would say, just to correct that answer, generally, no. If it was in connection with another item as a meal,
Yeah, and
it could be
that's when,
subject.
that's when she got the permit, was when she went in and she was selling it with other meals, then she got the permit, because if she sold it with a drink or something, then she was paying taxes, and she understood that. But prior to that, she had a hot bakery item.
Up to you.
So-
This is all.
Okay, can you repeat that? Hot bakery item to go, no seating, taxable or not
Yeah,
taxable?
well, generally, I mean, there's some other thing, whether there's admission or not, but generally, if let's say you're a bakery.
Yeah.
And you're just baking pies and bread and
To go.
and
To go.
to go, you don't have any place to sit, generally, you do not need a permit for those items because they were not intended to be sold hot. They might be hot when they're sold, but it's really the intent of it and whether it was a bakery item, and that's what comes into play.
Madam Chair.
So having a meat pie, a pot pie with other vegetables or whatever is in there that is not a bakery item. It's considered to be hot food, and there's a difference between just having a croissant and having this.
She didn't, no.
Mr. Horton?
Thank you, Madam Chair. Does consumption have anything to do with that? Law?
Well, if there were seating available or there was.
No, I mean, the intent to
Yes.
is intended to be consumed hot.
Intended to be.
Consumed hot.
Yeah, I would say that would, that's part of it, but you have to take a look at.
Baked goods, you go outside, you're in your car, they're a little warm, but,
Yeah.
they're not as served.
That's right.
Well, this
Yeah,
one,
okay.
takes out the can.
Yeah, it's a complicated area.
There's a motion.
Okay, so there's a motion and a second. Who made the motion?
I did.
Sorry, Mr. Runner made the motion, seconded by Ms. Harkey. Madam, Ms. Richmond, please call the roll.
Chairwoman Ma,
Aye.
Ms. Harkey,
Aye.
Mr. Horton,
No.
Mr. Runner,
Aye.
Ms. Stowers,
Abstain.
motion carries.
Okay, thank you very much.
Congratulations.
Oh,
So
is
we
that-
ruled in your favor.
You're granted.
Okay, thank you
Granted.
very much.
Thank you.
I had no idea. Thank you so much. Thank you.
Madam Chair, point of clarification, we granted the entire amount?
Yes.
Thank you so much.
No one had any,
Feeling
no one had
jealous
any.
here. That was sad.
Okay. All right, next item, Madam Clerk, Ms. Richmond.
So our next item are chief council matters. Item J, rulemaking. We have section 100 changes for J2. Regulations 1532, teleproduction or other post-production service equipment. Regulation 1533.1, farm equipment and machinery. Regulation 1533.2, diesel fuel used in farming activities or food processing. Regulation 1534, timber harvesting equipment and machinery. Regulation 1535, racehorse breeding stock. And Regulation 1598, motor vehicle and aircraft fuels.
Okay, Mr. Heller, please commence your presentation by introducing yourself for the record.
Good afternoon, Chairwoman Ma and members of the board. I'm Bradley Heller from the board's legal department, and I'm here to request that the board vote to authorize staff to complete Rule 100 changes to sales and use tax regulations 1532, 1533.1, 1533.2, 1534, 1535, and 1598.
Move adoption.
Second.
Okay, Mr. Runner moves adoption, Mr. Horton seconds. Without objection, motion carries. Next item, Ms. Richmond.
Our next item is item G, Tax Program Non-Appearance Matters Consent. Item G1, Legal Appeals Matters. Sub-item 6 has been previously pulled, and these items may be taken in one vote.
Okay,
Adopt staff.
any non-participation? No, seeing none, is there a motion?
Move to adopt staff recommendation.
Second.
Okay. Ms. Harkey moves, Mr. Runner seconds to adopt staff recommendation on items G1.1 to G1.5 and G1.7. Without objection, motion carries. Next item.
Our next item is G2, Franchise and Income Tax Matters. These items may be taken in one vote.
Any non-participation? Seeing none.
Move staff recommendation.
Second.
Mr. Runner moves staff recommendation. Ms. Stowers seconds to adopt staff recommendation on items G2.1 to G2.13. Without objection, motion carries. Next item.
Our next item is item H, Tax Program Non-Appearance Matters Adjudicatory. Item H1 is Legal Appeals Matters, and there's only one sub-item.
Okay.
Move to adopt staff recommendation.
Second.
Okay, Ms. Harkey moves to adopt staff recommendation, seconded by Mr. Runner. Without objection, motion carries. Next item, members. Ms. Richmond.
Our next item is H2, Franchise and Income Tax Matters. These items may be taken up separately or in one vote.
So there's how many petitions for rehearing? 2? 3?
There's one petition for rehearing,
Okay, 1 petition for rehearing.
one matter that was heard and not decided, and a Section 40 matter.
Let's just take it up separate. Okay. Any non-participation? Seeing none. Is there a motion?
On H2-1, move to adopt staff recommendation.
Second.
Okay. Ms. Stowers moves, Ms. Harkey seconds to adopt staff recommendation on H2-1. Without objection, motion carries. Next item, Ms. Richmond.
Next item is H22, case heard not decided.
Move to adopt staff recommendation.
Second.
Okay, Ms. Stowers moves to adopt staff recommendation, seconded by Ms. Harkey on item H22. Without objection, motion carries. Next item.
Our next item is H23, it's a Section 40 matter.
Is there a motion?
Move to adopt staff recommendation.
Second.
Objection.
Let's see. This is.
I'm objecting. I established a pattern that when I vote no on the case,
Okay.
I vote no on the
Okay,
summary
okay.
decision.
Okay.
It's not a reflection of the summary being incorrect.
No.
Okay,
Okay,
gotcha,
got it.
gotcha. Got it.
Okay, so motion by Ms. Harkey, seconded by Mr. Horton to adopt staff recommendation on item H3.
H23.
H23. With a no vote from Ms. Stowers. Okay,
So our
next item?
Our next item is item I, Tax Program Non-Appearance Matters. Item I1, Property Taxes Matters. There are 3 items which may be taken in one vote.
Move adoption. Staff recommendation.
Second.
Okay, Mr. Runner moves, Ms. Harkey seconds to adopt staff recommendation on all 3 items, item I-1.1 to I-1.3.
Constitutional function, I'm not participating.
Okay, with constitutional function, Deputy Controller cannot participate. So with the others, without objection, motion carries. Next item.
Our next item is I2, Offer and Compromise Recommendations. These items may be taken in one vote.
Move adoption. Staff recommendation.
Second.
Mr. Runner moves, Ms. Harkey seconds to adopt staff recommendation on items I-2.1 to I-2.5. Without objection, motion carries. Next item.
Our next item is the administrative session. Item N, consent agenda. We have N1, retirement resolutions for Julie Bruce, Aaron M. Little, Maria R. Malaneo, Janet L. Morgan, and Audrey A. Torres.
Thank you. We'd like to extend our appreciation to these retirees for their dedicated service to the State Board of Equalization. I think certain members are going to...
Julie Bruce is a business tax specialist 2 in the Internal Audit Division. She will retire in February after 27 years of state service. She began her career with BOE in 1989 as a tax auditor in the San Rafael and Santa Rosa offices. In 1992, she was promoted to Associate Tax Auditor, then to Business Taxes Specialist 1 in 1997, and Business Taxes Specialist 2 in 2007. We thank her for her service and wish her well in her retirement.
Ms. Dowers.
I have Ms. Erin Little. She is a Business Tax Specialist 3 in the Field Operations Department. She retired December of this 2016 after 28 years of state service. She began her career with the Board of Equalization in 1988 as a business tax representative in the Santa Ana office. She promoted to Business Tax Compliance Specialist 1 in 1991, Business Tax Compliance Supervisor 2 in 1994, Business Tax Compliance Supervisor 3 in 2006, Business Tax Administrator 3 in 2008. She lateraled to Business Tax Specialist 3 in 2014. Congratulations on your retirement.
And to Maria Malanao, Associate Tax Director in the San Jose District Office, retired earlier this month after 24 years of state service. She began her career with the Board of Equalization in 1992 as an auditor in the Oakland District Office and promoted to Associate Tax Auditor in 1999. Ms. Harkey.
I have Janet Morgan of the Riverside District Office. She retired on December 30th, 2016 after 24 years of state service. Janet began her career with the Board of Equalization in 1992 as an Office Assistant 1 with the old San Bernardino District Office, which later became the Riverside District Office. Due to her skills and knowledge, she was promoted multiple times during her career, including Office Assistant 2 in 93, Tax Technician 1 in 93, Tax Technician 2 in 2000, and in 2006, she was promoted to Tax Technician 3, where she acted as the lead cashier for the district for the last decade. Janet's work and family valued her for her positive attitude and attention to detail. While they're sad she's leaving the Riverside office, they know she will continue bowling, enjoying more time with her family, including her 6 grandchildren, and spend time camping her way around the United States with her husband. So board extends our congratulations on your well-earned retirement. Thank you for your service.
And Mr. Horton.
Thank you very much, Madam Chair. I'd like to thank and recognize Audrey Torres, Office Technician with the Ventura office for 36 years, working first 23 years in the compliance section and the last 13 years in the audit section. Both programs benefit significantly and tremendously from her skills, her ability, her compassion, and her commitment to serving people. She always had a smile on her face, even during the most stressful times, indicative of the fact that she seems to be more efficient and more effective under stress. So I think retiring might just do her well, depending on what happens with the family as she begins to travel throughout the world. She's fortunate to have family members that are on the East Coast, which means she will be traveling back and forth to the East Coast with her husband, having a joyous time enjoying the United States of America and all that it has to offer. In addition, Audrey plans to do more barbecuing, crafting, and exercising. Thank you for the invitation to the barbecue. All members, you're welcome to join me. We thank Audrey for her service and wish her the best of health and happiness in her next chapter of her life. May she be blessed in a special way.
Okay, thank you very much. And this time we have long employment histories, 27 years, 28 years, 24, 24, and 36. So congratulations to all of the retirees, and we wish you all the best. Okay, so Ms. Richmond, next item.
Next item is N2, approval of board meeting minutes for November 29/30, 2016, and December 14, 2016. Item N3, proposed revisions to audit manual, chapters 1, 4, 8, 9, 12, and 14, and compliance policy and procedures manual, chapters 2, 3, 5, 6, 7, and 8. And these items may be taken in one vote.
Move approval.
Second.
Okay, Mr. Runner moves approval, seconded by Ms. Harkey, to adopt staff recommendation on items N1 to N3. Without objection, motion carries. Next item, Ms. Richmond.
Our next item is item O, adoption of board committee reports and approval of committee actions. Item O1, the legislative committee minutes from December 14, 2016.
Move adoption.
Second.
Okay, Mr. Runner moves adoption, seconded by Ms. Stowers, to adopt all the board committee reports and approval of committee actions.
I think we just did the
We can- we
legislative.
just did-
The last
We just
legislative
did
one in
yes.
December, yeah.
From
Oh,
December.
okay, sorry. Last committee for December 14th, 2016.
Yes.
Okay, what happened to the other ones? Are you going one by one?
For item O2, we do not have those committee minutes yet.
For today.
For O3, we do not have those committee minutes yet. So we are on
Are we going to
O4.
adopt it at the end of this one or next?
I think they're still preparing them for your
I see,
signature.
okay. All right, so we'll come back. So we just adopted O1.
O1.
Okay.
And we're on O4 for the property tax committee minutes from December 14, 2016.
Move adoption.
Okay, Ms. Stowers, seconded by Ms. Harkey, without objection.
And you were just given
Adopted.
O5, the property tax committee minutes from this morning.
Move adoption.
Second.
Okay, I haven't looked at it yet. Can we hold until the other ones come back too?
Yes.
Okay,
Okay, withdraw.
all right. Next item?
So our next item is item P, other administrative matters. Item P1 is the executive director's report. Item P11 is the employee recognition award program nominees.
Good afternoon, Chairwoman Mon, members. David Gao, Executive Director. I am proud to present 56 nominees for an Employee Recognition Award in the 2015-16 award cycle. Specifically, individual awardees are recognized in the categories of customer service, extra mile, innovation, leadership, and supervisory excellence. Further, groups are recognized in the teamwork category. The board approved for each district to have one honoree in each individual award category and for at least one group to be honored agency-wide. 30 of the 56 employees before you are nominees in individual award categories, all equally representing the equalization districts, the out-of-state district, and headquarters. The remaining 26 award nominees from a group being recognized in the teamwork category. Should the nominees be approved, the Southern California award ceremony will take place at the April board meeting, and the Northern California Employee Recognition Award ceremony will take place at the May board meeting. I would welcome your consideration for approval on this matter.
Is there a motion?
Move adoption. Approval.
Second.
Okay, Mr. Horton moves adoption, seconded by Ms. Harkey, without objection. Thank you.
Thank you.
Motion carries.
Madam Chair.
Yes, Mr. Horton.
Mr. Gow, possibly, maybe we ought to do legislation, to give them a bonus of some sort, you know? Just thought I'd put that out. Nice bonus, you know? Education and outreach bonus.
Okay.
Okay, next item, Ms. Richmond.
Our next item is P6, the Administration Deputy Director's Report. Item P61, 2017-18 Governor's Budget.
Okay, I see Mr. Holtz will be making this presentation.
All right, good afternoon, Chairman and members. I'm Chris Holtz. I'm the Chief of the Business Management Division. Today we'll just update you on the progress of the Governor's budget proposal and the budget change proposals that were approved for the Board of Equalization. The Governor introduced his budget proposal on January 10th, and the fiscal year 2017-18 budget for BOE includes 4,799 positions and $688.4 million in funding. The majority of program funding continues to come from the general fund at $338.5 million. Directly billed reimbursements from local governments and other departments provide $197 million in funding. To summarize the budget change proposals that were approved for BOE, probably the most visible would be the Proposition 64 proposal on the Adult Use of Marijuana Act, made the recreational use of cannabis legal to people over the age of 21. In addition, Prop 64 makes it legal to sell and distribute cannabis as a regulated business beginning on January 1st of next year. The governor included $52.2 million for the regulation of cannabis in the budget year to fund regulatory activities, processing of licenses, and enforcement. Of this total amount, the budget provides the BOE 1.1 million and 1.9 positions in the current year, and 5.4 million and 22 positions in the budget year to implement and administer 2 new taxes on marijuana, notify businesses of the new tax requirements, and update its information technology systems to register businesses and process tax returns from retail sales. The California Healthcare Research and Prevention Tobacco Tax Act, Prop 56, passed by the voters in November of 2016, increases the excise tax on cigarettes and tobacco products effective on April 1st of this year. This tax also is applicable to e-cigarettes. The budget provides BOE with $6.9 million and 40.9 positions in 2017-18, the budget year, to implement and enforce the $2 per pack increase in the excise tax on cigarettes and e-cigarettes. In addition, the budget provides $286,000 to administer the cigarette and tobacco products licensing program provisions that passed in the 2016 special session, which requires the BOE to implement new license requirements, including annual rather than one-time license renewal fees and expansion of the definition of tobacco products. The budget provides $30 million, $17.2 million of that in general fund, and 65.4 positions for the implementation phase of the CROS project. The board approved an $85.2 million contract with Fast Enterprises on August 30th of last year to complete the project, and those payments are also included in these proposals. Finally, the budget provides $1.2 million and 3.1 positions this year, and $837,000 and 6.3 positions in the budget year to implement and administer a new legislatively implemented fee on consumers and manufacturers of lead-acid batteries beginning in April 1st of this year. And with that, I'd be happy to answer any questions that you had on the budget.
I have some questions. So this new cigarette tax includes e-cigarettes?
Yes, it does.
And have we been doing a report or study in terms of what the potential income will be on the e-cigarette side?
I believe the potential revenue, we've been relying on LAO figures on that. I don't have the revenue figures here with me, but I'd be happy to get those to your office.
But where BOE is going to be authorized and administered to collect the tax.
That's correct.
And currently, as I understand, the e-cigarettes, are there any regulations on where they can sell it? Because as I understand, there's no regulations. They could sell it anywhere. They could sell it at, manicure spots, barber shops, your car dealership. I mean, is there going to be regulations that will restrict where people can buy e-cigarettes?
I believe that any new regulations are still in flux, but any existing regulations, I don't believe that there have been any changes to the existing regulations on that.
And so who on our staff is going to be the point person for this?
That is a good question. I don't have that programmatic information, but I'll defer to program.
Okay, Mr. Gao.
Yes, I would refer to Mr. Richard Parrott, Administrator.
Okay.
He's the chief in the special taxes area.
So this is kind of an interesting new area, and
It is.
maybe we can put it on the agenda for future meeting to talk about e-cigarettes and kind of the whole scope and, you know, what the new legislation means and whether there's parameters around it, because it's going to be, I think, very hard for us to audit e-cigarettes. We'd have to go to every single, I don't know how the permit works and who can get it, if there's a permit that needs to be, you know, taken out on who can sell it, who can't sell it, where. Are they going to have to pay, presumably, the sales tax on it as well? So anyone who sells it would have to have a sales, take out a seller's permit? I'm not sure on this whole.
Correct. Yeah, we have done a special notice. I don't have it in front of me, but we'll get that to the members. But it does distinguish because electronic cigarettes and the fluid for them, the nicotine part of that is something new. The devices themselves, you know, are not subject to, as long as they're sold separately. But if they're sold with the nicotine or the nicotine on its own, that is where the tobacco products, the cigarette tax comes into play on that. So we will put that. We'll work with the chair's office and schedule it for a meeting if you would like, and also provide the members with the information that we are sharing with the industries.
Okay, and then for the Prop 64, the new cannabis revenues, who is it Mr. Parrott also?
Yeah, Mr. Parrott.
Preparing the estimates?
Yes, and Suzanne Bueller, Deputy Director, and Richard Parrott, the chief in that area, have both been working point on those matters.
And for the governor's budget, was it our shop that provided the numbers, or was it the LAO?
I believe it was the LAO that provided the revenue numbers.
Okay, so it may or may not be right? Where it's an estimate based on?
It's the best estimate at this time.
Okay. So we will be providing input and giving those numbers probably in the future once we start issuing those licenses?
Yes.
Okay. All right. Any other questions?
Thorough.
Okay. Thank you very much. There's no action item on this, right, Mrs.
No,
Richmond?
update only.
Okay, next item, please.
Our next item is P7, the Technology Deputy Director's Report. Item P7-1, cross-project update and actions.
Good afternoon, honorable members. I'm Chris Coyote, Cross Project Director, and I appreciate the opportunity to provide this month's brief update on the Cross Project. The end of 2016 brought a number of significant accomplishments in preparing for implementation activities in 2017, including finalization of the detailed vendor schedule, completion of technical environment implementations, completion of Gentac system demonstrations for all BOE staff and interested members, and completion of proof of concept demonstrations to validate integration of the new Gentac system with the BOE legacy systems. As we enter 2017, our initial focus will be on the evaluation of vendor-proposed revenue generation proposals and system design and configuration activities. For the revenue generation proposals, our vendor FAST will leverage the business intelligence capabilities of the Gentac system. These proposals will identify opportunities for short-term revenue generation programs that can be implemented prior to full implementation of Gentacs. The initial program proposal is expected to be delivered from FAST at the end of this month for evaluation. In addition, project team members and subject matter experts will completing their initial training on the Gentac system. This will be a preparation for system design and configuration sessions starting in March 2017 for the sales and use tax rollout, associated fees, fee tax, and fee programs, which is scheduled to go live in April of 2018. Our budget status as of the end of November 2016, percent expended for the current month is at 81%. Year to date is at about 34%, and project to date is at about 78%. The project is currently trending about 10% below projections. However, we anticipate that to over the remaining part of the fiscal year to creep up about 3% per month. A lot of the below spending was due to delays in filling staff and getting contracts awarded and on board. Those are all starting to progress as we move into the second half of the fiscal year. So we'll be closer to the actual projections as we get to the end of the fiscal year. That concludes our report for this month. I'm prepared to answer any questions you may have.
So are we on time and on budget?
Yes, we are.
Okay,
We're under budget, but soon to be equal to.
close to that.
okay. Thank you. Any other questions? No? Okay, thank you, Mr. Coyote.
Excited, thank you.
Next item, Ms. Richmond.
Our next item for today is closed session. The board members will now go into closed session to discuss settlements and personnel matters.
Have anything.
So we will turn to the committee minutes. We have adoption of the committee minutes 402, the legislative committee from this morning.
So moved.
Second.
Okay, Mr. Horton moves, Mr. Runner seconds to adopt the legislative committee minutes of this morning, January 25th, 2017, 002. Without objection, motion carries.
Item O3, the Customer Service and Administrative Efficiency Committee minutes. Those will be coming back next month for board adoption.
Okay.
So that takes us to O5, the Property Tax Committee minutes from this morning.
Move adoption.
Second.
Okay, Ms. Stowers moves, Ms. Harkey seconds to adopt the Property Tax Committee Board Reports, Committee Report of this morning, January 25th, 2017. Without objection, motion carries. Any other items, Ms. Richmond?
That concludes our items for today.
Okay, well, thank you all for coming. This concludes the second day of the meeting of the Board of Equalization. We will take a recess and convene tomorrow, January 26th at 11 a.m. for the annual meeting with the accountant assessors. Is it 11 a.m.?
Yes.
11 a.m. here in this same place.
Yes.
I forgot about that.
Thank you.
Good deal.